the Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. Welcome to our first day of our fall session here in Pittsburgh. As you may know, because I say it so often, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and the Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. We celebrated our 300th anniversary last year in Philadelphia. We sit today in Pittsburgh City County building, which is a 1917 granite Art Deco building, which was designed by renowned architect Henry Hornbostel. Let me say it again. Henry Hornbostel. The City County building houses our executive, legislative, and judicial offices for both the City of Pittsburgh and Allegheny County. Architect Edward B. Lee was responsible for the design of this magnificent courtroom, and I hope during your time here you'll take a moment to admire the majesty of this room. The murals in the room were painted by local artist Edward Trumbull. On the ceiling, you will see 3 great lawgivers, all framed by gilded plaster. Furthest from the bench is the Byzantine Emperor Justinian, famed for the Reformation and codification of Roman law. In the center is Moses, seated and holding the 10 Commandments. And finally, closest to the bench is the English King Edward I, who spent much of his reign in reforming the common law. To the left of the bench, you'll see a mural depicting William Penn, founder of Pennsylvania, and to the right, William Pitt, the first Earl of Chatham, who was held in high esteem by the American colonists after publicly supporting many of their positions. The city of Pittsburgh, as you know, is the namesake of William Pitt. It's truly an honor for our court to work in 3 beautiful courtrooms in Philadelphia, Harrisburg, and here in Pittsburgh. Before we hear the first case, I'd just like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. You may then begin by stating your name and the party you represent, and please introduce your co-counsel to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history, and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. In cases where there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as your prior counsel. And I remind you that we do not permit rebuttal. Please try not to interrupt the justices when they interrupt you. They're asking you a question because there are particular issues that they want to explore further. They're not doing it to trip you up. While there's no set time limit for oral argument before our court, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I ask that you conclude your argument. Mr. Minner, please call the first case.
Ann and Joseph Mertis versus Donald Drew O and B, representing Dr. O, Ms. Maureen McBride, representing Pelley's Mr. Joseph Messa Jr.
Good morning.
Good morning, Chief Justice. In
this discretionary appeal, we're asked to consider whether Pennsylvania Rule of Civil Procedure 4003.6 permits counsel in a medical malpractice case to speak with his client, plaintiff's treating physician, outside the discovery process when counsel for the physician is being sued and counsel for the treating physician are with the same law firm. Please proceed.
Good morning, Chief Justice and Justices. My name is Maureen McBride from the firm of Lamb Mackerlane, and I'm here representing Dr. Dong Jun Oh. Your Honors, we're here today to ask this court to reverse the Superior Court's decision, which found that the law firm of Scanlon Halley violated a discovery rule 4003.6 by discussing, he was a treating physician, discussing the plaintiff's case with him in circumstances where he was a client of the law firm. Rule 4003.6 says that information may be obtained from a treating physician of a party only upon written consent, and I won't go through the rest, except the rule shall not prohibit an attorney from obtaining information from, and the very first subsection, subsection 1, the attorney's client. In this case, the law firm represented Dr. O, and then a second doctor, Dr. Kim, had been subpoenaed and requested that the law firm also represent him. The rules specifically allow that if the doctors, the treating physicians, are law firm clients, that the law firm is free to speak with them without getting the plaintiff's consent.
Doesn't that interpretation really allow for a defense counsel to represent a treating physician under any circumstance? Because in this situation, the treating physician wasn't an employee of a hospital that was previously represented by the defense firm, and he wasn't an office group where he was a member of a group that was previously represented by defense counsel. And although I recognize that there had been some prior representation in some other capacity in the past, at the time that the treating physician came to the defense office, they were already representing the named defendant in the case.
That's correct, but there had also been criticism in the complaint of Dr. Kim, and we laid out those allegations. But clearly, he could have been brought in through the discovery rule. He could have been brought in as a defendant and was entitled to representation.
Well, I'm not saying he wasn't entitled to representation, but I don't see how you get around the fact that he was a treating physician and that law firm already represented a named defendant in the lawsuit, and regardless if the two doctors waived privilege or you can't waive 4003.6.
Well, Your Honor, with all due respect, I think this is a straightforward rule construction case. The plain language of the rule says if it's the attorney's client, then you can reach out, or I'm sorry, you can have conversations with the treating physician. It's a plain meaning rule. I mean, there's nobody.
That would allow an insurance company who really directs the coverage of these doctors to send every treating physician to the office of the defense counsel who represents the named defendant, and then 4003.6 means nothing.
Your Honor, again, with all due respect, that the rule, first of all, has been in place for a long time, and it's never been an issue. But this is, again, using rule construction precepts. The plain language of the rule says that this can happen. If the rule needs to be changed or needs to be looked at, that's a different issue.
Counsel,
but
can I follow up on Justice?
Certainly.
I think if you mentioned it's never been an issue, but ironically, did Scanlon Halley bring to the fore the problem Justice Mundy's talking about? In other words, if we apply your what you call the plain meaning approach, how would you advise us to rule in your favor and yet not greenlight the kind of practice Justice Mundy is describing, whereby the defense could always rope in, so to speak, the treating physician into the defense counsel camp through this means? I don't know what the principal distinction, in other words, would be between your scenario here and that whole universe of cases out there.
Well, I don't know of any case where any law firm has gone out and tried to seek out all the treating physicians. Before this rule was enacted, defense counsel could talk to any treating physician. The rule was enacted with these 3 exceptions. And there is no exception here that says you have to be a defendant in the case, which is what my colleague has said, that the rule should only apply if both parties are defendants. But that adds an exception to the rule that doesn't exist. So my argument is a basic argument. This is the rule. If we can't rely on the rules of civil procedure when we open the book and read them, and the rule doesn't say you can only represent one or you can't represent one who's not a defendant, that's not what the rule says. And so it erodes confidence in the rules if you can't just read this rule for what it is.
Well, Counsel, I have a question. How's it possible that Dr. Kim signed the conflict with the law firm prior to him signing the conflict, he had to engage in an ex parte conversation regarding the medical negligence before signing that conflict? How's that possible? You keep arguing that they're the client. I want to take you back to prior to signing that conflict, prior to retaining the same law firm. Share with me how the mere fact that the conversation between the law firm representing the defendant and the law firm now speaking to a potential client about plaintiff's case and defendant, how that does not, in effect, violate the plain language of the rule.
Okay, let me just say 2 things to that. First of all, there is no record in this case. There was no evidentiary hearing. The plaintiff's counsel, in seeking disqualification and sanctions, did not ask for an evidentiary hearing. The trial court said, and the trial judge said in her opinion, it's all based on speculation and conjecture. So we have no record before this court as to any conversations, any communications that occurred. The trial court also points out that the plaintiffs did not raise in their 1925 or on appeal any issue with respect to ethics or conflicts. This is a pure discovery rule. The issue is only about whether the manner in which you obtain information from a treating physician. And in this circumstance, it's a permissive rule. It allows a law firm to do exactly this. And again, I bring you back to, if you can't read the rules in the plain language, no one has said the words are ambiguous.
Well, Ms. McBride, let's do a plain text analysis, because I'm a little surprised by you're changing the words of the rule a little bit. You keep talking about a law firm. The rule doesn't mention a law firm. It says an attorney.
Correct.
Now, are you conceding or suggesting that we should interpret the word attorney to mean law firm?
No, and in this case, there were 2 different lawyers, so I take your point. There are 2 different lawyers representing the 2 different doctors in this case. And the other point that the trial judge pointed out was that there's no evidence that they talked to each other about the other client or any information. And again, there is no record in this case. And
well, you would concede that might be a violation if the attorney for the treating physician within the same firm shared information that attorney obtained from the treating physician with the attorney who is representing the defendant. That would be a violation of the rule.
Of this rule?
Yes.
I think that would be a different situation, and I can't speak to whether that would be a violation, but I think in terms of what's authorized,
it would be at least closer.
It would be a closer call. But here, I don't see any violation. And again, Dr. Kim had been represented by this firm before.
Well, I don't think that matters. I don't think. I think that's an unnecessary fact. I think the question is. I agree with you. I think it's a statutory construction case. I was interested in the idea that you were. Is there a definition of attorney that includes law firm? I'm wondering why you led with that.
Well, because again, I mean, it's the law firm that they're trying to disqualify from representing either of these doctors, right, or both of these doctors.
Does it make a difference, Ms. McBride, if there were a protective barrier or a wall established within the firm to separate? Because we don't have any indication that happened here.
Well, absolutely, but that's what Judge Gartley said. Judge Gartley said that there's no evidence that there were any communications between or among the two lawyers representing two of these different doctors.
Nor was there evidence, though, that there was a wall set up within the firm to separate them.
I don't believe, again, because there's no evidence. There was no evidentiary hearing. It was an oral argument.
The record that we received would show that the attorney Hayes, who was representing the treating physicians, showed up at a deposition in the place of the doctor defendant's counsel.
Again, there's no evidence of that, but the fact is that it was simply as a placeholder to say that she was going to be late for the deposition. There was no recording of that. That's not part of the transcript.
There is a transcript, because I thought that was an interesting point. I looked at the transcript, and in that transcript, the attorney that showed up did not enter, even indicated, I'm here, I represent the treating physician. I don't represent this other person, and they're coming late. I'm just getting on the call to let you know that that lawyer's going to be late. That was it. They didn't enter their appearance for anybody.
And what I was going to say is there's no objection on the record, and that gets into the issue of delay.
Counsel, before you get into delay, did Dr. O have the consent of his patient to disclose information?
So Dr. O
the treating
is
physician.
the defendant.
Oh, I'm sorry, Dr. Kim. Did Dr. Kim have the consent?
I don't believe he needed the consent, so I don't know the answer.
Why do you say that? We're looking at the straight language of the rule.
Right. It
So
says,
why wasn't the plaintiff, the patient's consent necessary? I mean, I read this rule, I don't know, maybe I'm simplistic. I mean, to me, I read this rule to say that if the patient gives consent, then the attorney does not need to get his or her own consent, period. That's a plain reading of the rule. But I just don't understand, I don't understand how the treating physician is exempt from requiring the consent of the patient before discussing or disclosing information, because that, of course, then gives the patient the opportunity to file a protective order or anything of that nature. And so I don't know, maybe I don't understand the full facets of this case.
so the treating physician, Dr. Kim, was subpoenaed. So clearly the plaintiff had agreed that Dr. Kim could
Why do you
speak.
say that? See, I actually don't see that at all. I mean, there's a subpoena issued, but that doesn't mean that the patient's records are free-for-all because the subpoena was issued. So, I mean, I'm just doing what you're suggesting, which is reading the rule as it's written. I would read this to say that the treating physician needs to get the consent of the patient before making any disclosure, and in the event that the treating physician has that consent, the attorney doesn't need to get additional consent. The attorney is then free to review the information.
Okay, I read that last sentence. This rule shall not prohibit an attorney from obtaining information as
From the
giving an
attorney's client, i.e. in this case, the treating physician.
Well, they were both treating physicians. Both Dr. Kim and Dr. O are both treating physicians.
And then the other doctor would need the plaintiff's consent to disclose information. And if he or she gets that consent, then the attorney doesn't have to get an additional consent to disclose information. I mean, I think I don't know, I think this is becoming more complicated. I also disagree with the proposition that the rules of professional conduct are not inherent in this discussion. I mean, we have de novo review over what the rule means, and we aren't going to read a rule so that it prohibits, so that it goes against the rules of professional conduct.
No, I understand that, Your Honor. My point was that the only issue that the plaintiffs had raised, because the trial judge denied the request for sanctions, denied the request for disqualification, and the plaintiffs argued only under the discovery rule that the firm, the lawyers, were not permitted to get information through discovery without going through discovery. That was the issue, and if you read Judge Gartley's opinion, she says they didn't address in their 1925 and didn't seem to appear to be addressing any issues with respect to conflict of interest or any ethical issues. And again, I think it does bear repeating, though, that this is, Dr. O had been represented by this law firm for at least 2 years before this issue arose. The plaintiff's firm was told in August of 2020 that Mr. Hayes would be representing Dr. Kim and did not file anything until April of 2021, raising this as an issue. And, the case law from the federal courts, and I know there's some superior court decisions, talk about delay and using this as a strategic, weapon to disqualify a law firm. But it takes away Dr. O and Dr. Kim's right to counsel. I mean, they both chose this law firm. The law firm is well respected. The lawyers involved are well respected. And to take that away, again, based on something that no one has said, the Superior Court didn't say this, and the plaintiffs aren't arguing that the language is ambiguous.
Well, the fact of the matter is the treating physician was the treating physician before he was ever the client of your law firm that you're representing.
Right.
That's where the problem is.
Right, but there's no prohibition for having one law firm represent more than one doctor. And this doctor's conduct had been criticized. I mean, the plaintiff said all the treaters.
I think that 4003.6 definitely precludes the same law firm from representing a defendant doctor and the treating physician.
Well, what I'm saying is that if they were both defendant doctors, the plaintiffs are saying if they were both defendant doctors, that would be okay. But Dr. Kim's conduct was implicated. I mean, he was criticized. He was not yet a named defendant.
The
but
statute had run.
I was here a few years ago on the Conaboy case where they were trying to use the discovery rule to bring in a defendant after they had taken a deposition. I mean, it happens all the time. He could have been a defendant. That's why he wanted representation. That's why he reached out to that law firm. So I think...
So is your argument that this situation deserves some express consideration to make it circumvent 403.6, or is it that the plaintiffs waived their argument, or both?
Well, first, my argument is that when I read the rule, and maybe I'm overly simplistic, I read the rule as saying this last sentence, the rule shall not prohibit an attorney from obtaining information from the attorney's client. There's no doubt in this case that both of these defendants, and Dr. Kim in particular, was a firm client, a lawyer, the attorney's client. Therefore, I don't believe needed consent, and I believe had the right to have those discussions. So my argument is that we have rules. The rules, I mean, I've written a ton of briefs where I've said, and this court has held, we have to apply the language when it's clear and unambiguous, and there is no...
You could always take the treating physician to the law firm, and then voila, they're a client. They don't have to behave under the mandate of the rule.
Well, some of that, and I did see that in the plaintiff's brief and in the amicus brief, it suggests that there's going to be some nefarious conduct. I mean, first of all, and the suggestion that the doctors would somehow change their testimony or would be dissuaded from testifying.
I'm not suggesting any of that. I'm just suggesting the factual situation of this case, at least in my view, violates that rule.
But I think that, again, the language is clear. If the rule needs to be changed or modified, certainly, the rule can be looked at. But I don't think you can take a rule that has plain language like this and then tell people that because it may be used improperly, that the words don't mean what the words say. That's the problem that I have, because I think unless people, if they can't rely on that, then they're going to have to go and, read all the case law to figure out what the rules mean. But again, that's not the argument. It's not an ambiguity argument. It's that this court did not envision. That's what the Superior Court said. This court did not envision this circumstance. And I say, yes, this court did, because it has this exception.
Well, I don't know if That's like saying the General Assembly envisions every circumstance when they write a statute. I mean, this could be a circumstance that the court didn't envision when it approved that language in the rule. I'm not sure whether we envisioned it or not as particularly persuasive. I think the question is, what does the rule provide? And it may very well be that the rule's language is as you say it is and allowed this to happen and the rule needs to be changed. But I don't know. I think for me it falls down to a simple question of is attorney synonymous with law firm? If attorney is synonymous with law firm, I think you have a problem. If attorney means attorney, and it could be attorney within firms, then you might be okay.
Yeah, and again, because there's no record, and you know, if
well, that also is an important point,
right?
Too,
and you know, the Superior Court found a violation without any fact finding by the trial court, and then said that the trial court should fashion a remedy for the violation. And of course, the request was for disqualification, which is the harshest of all sanctions, which would be unfair, certainly, to the doctors in this case, especially Dr. O, who had been represented for 2 years. And yet, you know, there's no sort of due process or considerations for the choice of counsel of these doctors. So again, my argument is I was going to say this is the easiest case you would have all day, but I guess not. That it's a plain meaning argument, and I think that the lawyers in this case did nothing wrong, and they followed the rule exactly as this court envisioned it. So thank you, Your Honor.
So is it just a coincidence that the rule uses the phrase ostensible employee of an attorney's client? That ostensible agency concept is really so tied to medical malpractice cases. Do you see a concerted thought process there on the court's part when they pass this rule to capture malpractice cases with this rule and those exceptions?
Well, we went back and tried to find the history, and I don't think there is any when the rule was passed, so I can't speak to that. I agree with you that ostensible agency is something we come across all the time in medical malpractice cases, and I'm not sure that I've ever seen it applied in any other context. So I agree with you. It's probably referencing that. Thank you, Your Honor.
Thank you, Ms. McBride. We'll hear from Mr. Mesa.
May it please the court. Good morning.
Good morning.
Good morning.
Madam Chief Justices. I'm Joe Messa on behalf of the plaintiff Bobby Ann Mertis, plaintiff Aplt. With me today from my office is Angelo Theodosopoulos, as well as David Paul, who is amicus on the brief on behalf of the Pennsylvania Association for Justice. Rule 403.6's sole purpose is to prevent defense attorneys from contacting plaintiffs treating doctors outside of the discovery process and methods authorized by Chapter 4000 of the rules. We're here because Dr. O's counsel admitted to unauthorized private contacts with Ms. Mertis' treating doctor, a non-party, that they attempt to justify through an ex post facto retention agreement and ex post facto conflict waivers between defendant Dr. O and treating Dr. Kim. The interpretation of the rule that the Scanlon-Howley firm urges the court to accept leads to an absurd result. The exception would swallow the rule that was intended. I'm sorry.
Can I interrupt you, Mr. Messa, and ask you this? Is it an absurd result that we created by writing the rule this way? In other words, is the correct result in this case for Ms. McBride to win, and then for us to change the rule tomorrow to prevent this problem from appearing again?
I would suggest not, Justice, because the rule is a restrictive rule, not a permissive rule. The rule is a subset of the Chapter 4000 group of rules, and the rule starts by saying information may be obtained from a treating physician only upon written consent or through a method of discovery authorized by this chapter. Those methods of discovery for a treating physician authorized by Chapter 4000 in a circumstance like this are subpoena for documents or subpoena for deposition. The subset of the restriction in the rule, shall not prevent, does not create an avenue for ex parte contacts. It merely identifies a limited exception for communication with a defendant client, as was raised before, really in a medical malpractice context where a defendant is a physician and also a client and treating physician, and their employees or ostensible agents. Statutory construction rule section 127 says the object of all interpretation and construction of rules is to ascertain and effectuate the intention of the Supreme Court. And if you look to subsection A, the Supreme Court does not intend an absurd, impossible of execution, or unreasonable result.
Well, counsel,
yes, Justice.
To determine the intent of the court as to interpret the intent of the General Assembly, you cannot ignore the plain language of the statute or the rule, and you cannot add words to the rule or take away words from the rule. You just added a word to the rule about a defendant doctor. That it doesn't say defendant doctor.
Doesn't say defendant doctor, but the setting, as was raised previously by Justice Donahue, that we only see that ostensible agent in the case of a physician.
Well, let's assume your construction is correct, because I think there's an evidentiary issue, too, that we have to talk about. Do you have any evidence that Attorney Hayes relayed any information from Dr. O to Attorney Doherty or Hillebrand?
Yes. If you look in the record, there is a letter from Attorney Theodosopoulos after the deposition of Dr. Singh, the deposition that Attorney Hayes showed up at on behalf of Dr. O. After, not on the transcript record, but after the communication off the record between Attorney Theodosopoulos and Attorney Hayes, where Attorney Theodosopoulos said, you can't be here, this is not appropriate, you can't be here on behalf of Dr. O. He then backpedaled, made a call, suggested she was coming later. That is outlined in the letter which was forwarded to...
I think you're missing my question.
I'm sorry, Justice.
Is there any information, because the rule is about information, right? You can't get information from a treating physician other than... So the information would be information about the case, substantive information, discovery type information, right?
I believe the rule is about the method of contact, and it prevents contact.
Well, it says information. Doesn't it say information? Other than through discovery. You only get information through discovery, right? That's what the rule says. So it has to be discoverable information, meaning information that you would seek through discovery.
Yes,
you wouldn't, and so is there any evidence in the record, and you didn't have an evidentiary proceeding, so I'm not sure how you're going to answer this. Any evidence in the record that Attorney Hayes relayed information that was otherwise only available under the rule through discovery to Attorney Doherty or Attorney Hillebrand?
The evidence, Justice, is only that he showed up at the deposition on behalf of Dr. O. That is outlined in the subsequent letter, their conversation off the record from Mr. Theodosopoulos to...
Okay, so that's what I'm saying. So there is no evidence in the record that Attorney Hillebrand or Attorney Hayes, in his conversations with his client, the treating physician, Dr. Kim, relayed information to Attorney Doherty and Attorney Hillebrand that they were only entitled to get through discovery.
Well, we're talking about, Justice, a six-lawyer firm and a attorney who's showing up representing Dr. O.
I'm asking if there's any evidence, because it was your burden. It was your burden at the hearing. It was your burden and your motion at the trial court.
Yes, Justice.
To show that there was an improper communication. Not that there was an improper attorney-client relationship or things like that, but that there was an improper ex parte communication, a sharing of information that shouldn't have happened under the rule, but pursuant to the rules of discovery, document requests and interrogatories. Where is that in the record?
That there was the rule is the showing that occurred was a violation of the rule by inappropriate ex parte contact with the treating doctor. That's what the rule calls for.
To obtain information.
For the purpose of obtaining information. But what happened was Mr. Hayes clearly obtained information from the treating doctor, Dr. Kim, that he wasn't otherwise permitted to obtain.
That may be true. I'm claiming, did he relay that to Attorney Doherty and to Attorney Hillebrand?
But the information that's prevented pursuant to the rule is communicating with that treating doctor, ex parte, Dr. Kim, in the first place.
So he couldn't communicate. How are you doing, Dr. Kim? Did you play golf today? How are your kids?
No,
that's prohibited?
Communication about a patient, ex parte communication
I agree
about
with
a
you.
patient. So here we have absolute proof in the record that occurred, and I can point to the court. Defense counsel admits in the record at the hearing ex parte communications with Dr. Kim. He says, and this is at page 252 of the record, notes of testimony at 8:8-25. Mr. Hayes says on the record, upon contacting me, Dr. Kim was made aware that our firm was already representing Dr. O in this matter. And then he goes on and says, and this is at the record page 253, notes of testimony 12:3-10, Attorney Hayes said to the court, Dr. Kim's written consent was provided by him, after being informed about the allegations set forth in plaintiff's complaint. Now, counsel for Dr. O here says, well, we set out form allegations in the complaint that implicate Dr. Kim. Not true. If you read the complaint, what's there is a factual recitation of what occurred and what did not occur. Pennsylvania, as a fact-pleading state, requires that. The factual allegations relate to Dr. Kim.
And everything that you just said, though, and I apologize for interrupting, but I'm not sure I even heard an answer to my question yet. You keep talking about procedural things, a waiver, the allegations in the complaint which were already publicly available. Is there any information in the record that you showed that Attorney Hayes received from Dr. O or from Dr. Kim that you're claiming he could only receive through discovery?
He showed up at a deposition to represent a defendant that was not
I looked at the
client.
transcript. It doesn't appear anywhere where he says, I'm representing the treating physician defendant, or I'm representing the defendant. It doesn't say that anywhere.
That's why I directed the court to the letter the same day from Mr. Theodosopoulos
Well, that's from Mr.
to Mr. Hayes outlining that.
I understand, but that's an allegation.
They don't ever say that that's not true in any written form.
Okay.
So the violation is the method of contact that's not permitted, ex parte contact. And back to the complaint very briefly. The complaint only talks about Dr. Kim as it relates to Dr. O's liability. Dr. O is the anesthesiologist that causes the injury, is responsible for the anesthesia. The complaint makes the allegation that Dr. O never provides the patient with information about consent, what the risks, complications, etc. are. It then goes on to talk about the Dr. Kim and the nurse, the other people who had any conversations with Ms. Mertis, never informed her about allegations relating to the anesthesia. Wasn't their obligation. The point was only to articulate that Ms. Mertis never got that information from anyone at any point in time.
Mr. Mesa,
Yes.
would it make a difference in your argument if the firm had constructed a wall, a protective barrier between the two attorneys?
No, Your Honor, because the contact in the first place is what's prohibited. And this is not a circumstance where the firm represented Dr. Kim already. They went, in this case or otherwise, they went out and actively communicated with him, had him sign a retention agreement, and then had a further communication about the complaint and what they claim were allegations made against him, and asked him to sign a waiver.
Does it make it, just teasing that out for a minute, counsel, does it make a difference that in this case, apparently Kim called Hayes because he called the carrier and said, hey, I've had Hayes before, can I have Hayes again? As opposed to a scenario where if Ms. McBride if Dr. O wins here on this appeal, then the slippery slope I was asking her about looms, where presumably defense firms could institutionalize a practice like this unless we change the rule, or is this idiosyncratic and somehow isolated to its own circumstance?
No, I don't believe it is, Your Honor. I believe it's across the board. It doesn't make a difference under the circumstance. Otherwise, we would have the problem that Justice Mundy raised earlier. Any time, like in this case, physicians were represented by the same insurance carrier, they could have contact. Anytime they were represented, I mean, we have huge mega law firms today that represent doctors in personal matters, business matters, medical malpractice cases, and otherwise. Anytime a law firm represented more than one doctor who happened to be involved in a medical malpractice case that was a treater.
Medical malpractice case.
Could be anything.
It could be a slip and fall.
Absolutely.
The defense firm is hired to represent the property owner, and then the treating physician goes to the defense firm for representation when he's subpoenaed for his deposition.
And yes, Justice, and would give unfettered access.
Absolutely.
Not permitted under the rule.
I mean, there's more room for harm here in that latter situation.
Yes, Justice. I mean, this, bless you, this would open up the rule to be utilized as a discovery tool, to be utilized as an affirmative discovery tool. Anytime this circumstance exists, all you have to do is go out and get a retention agreement, and then you open up a whole new avenue of discovery. That was never what this rule intended. This rule was intended to restrict the communications and information that could be obtained from a treating doctor, which is why it sets it forth as a restrictive rule.
What if this court, whenever this court drafted this rule, messed up and failed to envision scenarios like this? Why is Ms. McBride wrong that she's entitled to stand on the plain language and that Hayes can get away with this, so to speak, until we change the rule? Why is she wrong? That's not exactly her argument. She gave the court, I think, more credit than the court deserves, which is very diplomatic of Counsel McBride. But why, in other words, if the court didn't do this by design, but rather by inadvertence, why isn't she entitled to stand on the language of the rule and then have you rely on us to fix the mess we made tomorrow or the day after tomorrow?
Well, I think characterizing it as a mess is a little bit of an overstatement. It could be construed in a way that we did not originally intend.
It looks kind of messy. The whole situation looks very very bad, doesn't it? I mean, it stinks.
I would suggest, Justice, that on its face, if you look at the rules of statutory construction, the rule is clear. It is a restrictive rule. It prohibits the contact other than in one setting, ex parte communication through a rule, another discovery method authorized by the chapter. That's a clear limitation. It's a restriction. And then it makes exceptions which only apply in very limited circumstances that this is a twisted interpretation of. And when you look at the rule of statutory construction, that Section 128 that did not intend a result that is absurd, impossible of execution, or unreasonable, which is just what this is, if you're then allowing an exception to a restrictive rule to open up a retention agreement as a method for anybody under the sun to get discovery from any treating physician anywhere that they either have contact with in the future or have contact with, had contact with in the past, or they happen to be represented a treating doctor by the same law firm for something completely different, or happen to be insured by the same insurance carrier otherwise. That result under the rule of construction is not reasonable. And the Supreme Court Rule Section B of 128 says the Supreme Court intends the entire rule or chapter to remain effective and certain. And for the entire chapter, yes, Justice.
We know how to craft an ex parte communication bar rule. This rule does not use the words ex parte communication. Again, it's a discovery rule. It's a rule about gathering information in violation of the rule. You're turning it into a contact bar as opposed to an information gathering bar.
It's a limitation on discovery, and it limits the method that can be utilized.
To get information. To
get information.
Right.
It limits the method.
I agree with you. I'm not disagreeing with you. I'm still back, and I want to give you one more shot at it, about what information did the law firm or Attorney Hayes share with the two attorneys representing the defendant information share in violation of this rule?
Well, we know for sure they didn't set up a conflict wall.
Okay. What information? Do we know? Do we know if there was any information sharing, or are we just assuming there was information sharing?
It's a 6-lawyer firm. He shows up representing the defendant in a deposition.
So
there's
you're
no
saying
conflict.
by implication or by inference?
Well, that and the fact that the communication or the method of contact was prohibited in the first place pursuant to the rule. Now,
They also got a waiver of the conflict from both physicians.
True.
A waiver has to be knowing. I mean, I don't understand, and I think Justice Doherty was touching on this earlier, how you get a knowing waiver of a conflict, telling someone your interests can be adverse to each other.
And that
I don't think it's enough to say, take our word for it, they could be adverse to each other. You need a knowing waiver of a conflict of interest.
And that, Justice, goes to the heart of the issue and the mischief that courts who have addressed this, the Superior Court, even then Judge Justice Brobson in the Sox case in a workers' comp setting, trial courts that have addressed this issue since, there's not a single case since this rule has come into effect where a court has said that this conduct is okay. Every case is the opposite. So the way it's been construed, yes, Justice.
I think it looks like a lot of mischief. My only question is whether we can get to that given the language of the rule that we wrote. I'm very troubled by the conduct here, very troubled by it. I'm just not sure whether we get to that in this context given the language we wrote. And of course, I think it's unanticipated by the court when it wrote that this would happen. I just don't know how we get out of this. Well, I'm going to use my word mess again that the Chief doesn't like here.
I believe, and I won't call it mess, and it's not of this court's doing, but I believe the other thing to look at to address this issue is the purpose and historical development of the rule. This rule came into effect in 1991 by the Supreme Court, and it came into effect after the Moses versus McWilliams case in 1988 that really turned the rule on its head, where the Superior Court said, well, we think that this is an effective and efficient way to gather information, to have private interviews with treating doctors. And that had occurred when prior case law, for example, the Alexander versus Knight case, which was affirmed by the Superior Court, and in federal court, the Mannion case by then Chief Justice Nealon, other trial courts said, can't do this. This is not appropriate. Moses comes out in late 1988. Then trial courts start to do an about face, which changed what had happened before. Then 2.5 years later, after Moses, and when trial courts in the interim are following Moses, the Supreme Court comes in 1991 and promulgates Rule 4003.6. And the reason there's not a lot of background or information there is because they promulgated it without notice and comment period. And here's the reason: because it was required in the interest of justice and efficient administration of the court. That's what happens in the wake of Moses, which turned the history of this issue of ex parte communication with treating physicians on its head from 1961, which began with the Alexander case, through 1988. So I think if we look at the historical development of the rule and the purpose of the rule articulated before and since, even as Justice Brobson, then Judge Brobson, said in the Sox case, to prevent defense counsel from improperly influencing a non-party physician from testifying in favor of his client against his patient or dissuading him from testifying altogether. That's the mischief that was referred to. And there are compelling policy reasons to interpret the rule that underlie that adoption of the rule in 1991. The recognized privacy interests underlying the doctor-patient relationship, the physician's duty of loyalty to their patient, safeguards against the revelation of materials that are irrelevant and personally damaging to the plaintiff, tort liability for physicians who breach their duty of privacy, the potential to improperly influence a physician or dissuade the doctor from testifying altogether. What do we have here? We know facts. They set forth, the Scanlon Howley firm, in their brief. Oh, well, you could be sued next. you could be the next defendant here. We know that was communicated to him. They say that during the time that there was a communication about a waiver of a conflict. So they have to have that conversation with him for waiver of the conflict.
Counsel, was
Yes,
Moses a
Justice.
medical malpractice case? Was Moses a medical malpractice case?
Moses was a medical malpractice case, and yes, involved communication with treating physicians, 100%.
Yeah, counsel, when you take on the representation of a plaintiff who has a medical malpractice or any personal injury case, and you write to the treating physician that you represent the plaintiff, do you also include an authorization signed by the plaintiff that the doctor is free to disclose the medical information to you?
Of course, absolutely, under all
Your letter
circumstances.
is not sufficient to do that. You need the written consent of the plaintiff in order to get that information.
Absolutely, and that goes to the right of privacy, and that privacy right is held by the patient, not the physicians. So a waiver between Dr. Kim and Dr. O is really of no moment with respect to this, because they cannot waive Ms. Mertis's rights under the
You
circumstances.
wouldn't get that information from that doctor unless you had a written authorization from your client who you represent.
Absolutely, and that's one of the methods under the rule, written consent, that was never given here.
That's an interesting point because viewed in that light, one could say that what happened here is a subordination of the physician-patient privilege to a new attorney-client relationship.
It's a confidentiality of the physician-patient relationship.
You see my point?
100%. It's an issue with respect to the protection of the rights of the patient and their communication with their physician and information that otherwise is only discoverable through the methods articulated in the rule, which is why it's there.
That's what this rule is about.
Yes, correct, Justice.
The inclusive nature of this rule in the first instance. That undoes Moses.
And that, as I said, the purpose and historical development of this rule is another place this court can look, and I don't think we need to go outside the rule or change the rule. I think when you look at the entire landscape of the history, the historical purpose, how the rule's written, the restrictive nature, and the exceptions, what it's intended to protect, the right of the patient and their patient-physician relationship, it's clear.
All right, any other questions for Mr. Messer?
One follow-up, Chief, if I can. If this firm had represented, I want to make sure I got the attorney, the doctors right, Dr. Kim, in a real estate matter, when this matter came in against Dr. O, was the firm required to cease communicating, or in your words, contacting Dr. Kim because of its representation of Dr. O?
They could not communicate with him on any issue related to this case or this patient other than through the rules through a signed waiver or through a subpoena. So the rule is designed.
So it's not. I just want to again. I'm trying to keep it narrow. It's not an ex parte communication bar. It's a bar about talking about information relevant to the case.
I think there would have to be also a conflict wall that was erected under those circumstances to ensure that that communication, just to protect the law firm, didn't occur. But they certainly could not communicate with respect to anything related to this patient, this patient's rights, and their private information, which is what the rule is designed to protect in the first place.
Okay, thank you, Mr. Messer.
Thank you, Justices.
Very well argued by both counsel. Mr. Minner, would you call the next case?
AUUE Inc. versus the residents of Jefferson Hills, representing residents of the State of Stewart, representing AUUE on the state of Pittsburgh.
In this discretionary appeal, appellee AUUE Inc. filed a zoning permit application with the Borough of Jefferson Hills seeking approval and use certification for UPMC South, a medical center which would include a hospital, a medical clinic, medical professional offices, and a helipad. The Borough zoning officer approved the application with respect to the property's use as a medical center, conditioned upon appellee's compliance with zoning requirements via the land development application review process. We are asked to consider whether a zoning officer may issue such a use permit while deferring consideration of other zoning compliance issues to the land development process. Good morning.
Good morning. Thank you, Your Honor. My name is Daniel Stewart. I'm with the law firm Marcus and Shapira here in Pittsburgh. And along with my partner, Jonathan Marcus, we represent the 67 residents of Jefferson Hills who are challenging this development. And on behalf of the residents, we want to thank the court for taking this case, because while it presents a very straightforward issue, it is a critical one under Pennsylvania land use law. And it is as basic as answering the question, what is a zoning hearing board supposed to do? Now, the answer as applied in this case is simple. When a developer submits a zoning permit application that violates the zoning ordinance, the zoning hearing board must deny the application. Or, at minimum, the zoning hearing board has the power to deny the application. And that's all that happened here. UPMC submitted its zoning permit application for UPMC South to the zoning officer, and the zoning officer gave UPMC a zoning permit. The resident objectors challenged the issuance of that permit and proved over 9 nights of hearings with the zoning hearing board that UPMC's application did not comply with the zoning ordinance in 5 ways. And based on those violations, the zoning hearing board made a decision to overturn the issuance of the permit. That is exactly what zoning hearing boards are supposed to do. The Commonwealth Court decision, which reversed the zoning hearing board, is problematic because it completely undercuts the reason that zoning hearing boards exist. And it does so in contravention of the MPC and the Jefferson Hill zoning ordinance. The Commonwealth Court reversed the board's decision, not because the board misinterpreted the ordinance, or because UPMC's application actually does comply with the ordinance, which it does not. The Commonwealth Court held that the board erred because the board enforced the ordinance. The Commonwealth Court decision is telling the Jefferson Hill zoning hearing board and zoning hearing boards throughout the Commonwealth that they are not allowed to deny zoning permits, even when it is proven by objectors that the permit application violates the zoning ordinance.
Well, I think it's a little more. I think it's a little more nuanced. In fairness to the Commonwealth Court, I think the Commonwealth Court said that the zoning hearing board's scope of review is limited to the relief that was sought in front of the zoning officer, and in this case, UPMC is taking the position that it only sought a quote use permit, which essentially is this use permitted in the zoning district, which I'm not even sure you need one. If it's permitted, it's permitted. But that's really the question. Is the zoning hearing board cabined in its review to the limited issue that the applicant presents to the zoning officer?
So that is, I agree with you completely. That is certainly one of the issues. And I think the way UPMC had phrased it was a jurisdictional type question.
Right. It's a standard and scope. I mean, it's a scope of view question. The zoning hearing board is the adjudicatory body, not the zoning officer.
That's correct.
The zoning hearing board creates the record, makes the findings of facts, the conclusions of law, and the question is that body under the MPC limited to the narrow relief or question that the zoning officer decided?
And I think on that question, the answer is no. The board is not so constrained. When the zoning officer makes a determination, the only participants in that determination would be the applicant, UPMC, and the zoning officer. The residents find out about the issuance of the permit. They then challenge it. The board's decision is based on the challenge brought by the residents and the evidence presented at the board's hearing. The board is not constrained in its review to simply do the same thing that the zoning officer did. So here, the zoning officer said during his testimony that the only thing that he did was read one page of the 220-page ordinance and say a medical center use is permitted in the office park district. That is the error. His obligation under the MPC is to review and apply the whole ordinance.
Well, wait a minute. I thought that was really what he was supposed to do, was decide on the use.
Yeah, I think the problem I have with this case is there's the strict application, and then there's how it happens in real life. And certainly, and I think you sort of conceded this, the zoning officer had within his or her power to simply look at the statute and say, yeah, I'll give you a use permit for what it's, or the ordinance, I'll give you a use permit for what it's worth. It's a permitted use. Go have a great time. It doesn't really mean anything. The question is, so the zoning officer wasn't prohibited from doing that, at least in my view, my understanding of the law. The question really is, was the zoning hearing board required to do that same thing? Or could the zoning hearing board take a broader look at the zoning ordinance based on the objections raised by the parties and say, yeah, we're going to do that, but you still have problems, or we're going to grant it with conditions, or we're just going to deny it? My understanding as the law, the zoning hearing board could have done all of that.
So I would agree with you on the second point. On the first point about what the zoning officer can do in the first instance, I don't think that's right. The Jefferson Hill zoning ordinance says that no permit of any kind shall be granted for any purpose except in compliance with the provisions of this ordinance. So there is no such thing as a use-only permit.
Oh, sure there is. I mean, there's
two things, right?
Yeah, the zoning, the ordinance references use permits specifically, and in development, the way development works is a developer doesn't want to spend a whole heck of a lot of time on a saldo plan and all these other things that the zoning part of it is minimal. The expense is on the land development side, the engineers and everything that you need. So if there's a question over a use in the ordinance, developers will often go to the zoning officer and say, can you just review this and make sure that this is a permitted use and give us use approval? Not that we want full zoning approval. It's just before we go to the expense of the saldo, we want to resolve the question of whether this is a permitted use. That happens all the time.
Well, the saldo is a separate statute that is not at issue in this case. Use is used in the ordinance. It means two things. It's the proposed use, right? Hospital in office park or restaurant in commercial. But a use, and this is in the Jefferson Hills ordinance, it's 101.6, is always subject to the regulations in the ordinance. So the question is not...
Every use is subject to setbacks and lot size and everything like that, but that doesn't mean it's not a permitted use in that zoning district.
And it seems to make sense as a preliminary question.
Yeah.
But those are the issues that were the violations. So
I agree. I don't think you and I are disagreeing.
Okay.
I think the point is, it doesn't really, my question to you is, does it really matter what the zoning officer did? It matters what the zoning hearing board is empowered to do.
Okay. I agree with that completely.
And the zoning hearing board could have done, and you don't have to agree with this part, could have done exactly what the zoning officer did. But they didn't. And the question is whether the zoning hearing board acted within its authority to say, we're not going to give you a use permit because there are so many zoning issues here that we want those resolved before we stamp this as going forward.
Yes, and I think that is absolutely the main issue in this case. It is about the zoning hearing board's authority, not what the zoning officer did. And in this case, the zoning hearing board is presented with facts over 9 nights of hearings that UPMC's proposed development on the application that they submitted, based on testimony from their own witnesses, does not comply with the ordinance. And the only thing the board decided on that point is, if you don't comply with the ordinance, we're not giving you a permit. The board interpreted the Jefferson Hill zoning ordinance in an entirely reasonable and justified manner. We would say the manner that they're obligated to interpret it that way, but even if it's optional, even if the board could have gone the way the zoning officer did, the board chose not to, and that is an eminently reasonable decision. It comes down, when it comes to this court, it is a question of what decision is on appeal at this court and what's the standard of review. The decision that came up that is in front of this court is the zoning hearing board's decision to say, we're not giving you a zoning permit when your application is non-compliant with the zoning ordinance. And under the reason that matters, the reason the distinction that Justice Brobson was making matters, is because in this court, deference and great weight is typically given to a zoning hearing board's interpretation and application of its own ordinance. There is no weight given to a zoning officer's decision if it is rejected by the board, as it was here. So the question for this court is the board's decision so ill-considered and illogical that it's an error of law that has to be overturned? And the answer to that should be no, because there's no way of reading the Jefferson Hill zoning ordinance or the MPC as prohibiting a zoning hearing board from looking at an application that has plans submitted and created by UPMC, hearing evidence, seeing that the plans don't comply with the ordinance, and saying, we're not giving you a zoning permit. There's no way to read any statute at issue in this case as prohibiting the zoning hearing board from doing that, and that's all we're asking the court to do.
Counsel, and then what? Let's say that this worked out the way you wanted it to work out, and the Commonwealth Court affirmed and said, okay, no zoning permit. What happens to the UPMC project?
That would be a matter for UPMC. We would be back.
In terms of the municipal planning code, what's your next step?
They would have to, if they want to continue with the development, their next step would be to submit applications that comply with the zoning ordinance.
By consolidating parcels?
Correct? I would.
Isn't that what was anticipated here? And isn't that exactly what these zoning officers said? I'm giving you a use permit, but it's conditioned on you working out all of these underlying issues with the zoning code. And is it reasonable for the board itself to say that's not a legitimate approach to a project of this size and complexity?
So what the zoning officer attempted to do is not to condition the issuance of the permit on some condition created by the zoning officer. What the zoning officer attempted to do was say, I'm going to give you an opinion that a medical center is allowed in the office park district, subject to you complying with a zoning ordinance at the subdivision and land development step. Mm-hmm. That is an abdication of the zoning officer's duty. Because
Counsel, with all due respect, you're wrong. It happens all the time. At the Planning Commission, when a saldo is submitted, you know who's sitting in the Planning Commission meeting? The zoning officer. The plan goes to the zoning officer for an opinion. The zoning officer issues opinion to the Planning Commission saying these are the zoning deficiencies in the plan. This is the way it happens in real life. It's not an abdication. The Planning Commission has no authority to approve the zoning. That's why the zoning officer is in the actual meeting and reviews the subdivision plan.
I would agree with you. In this case, what was attempted was to push it to the governing body, for the governing body to address what were proven zoning violations. The governing body does not have the jurisdiction. If you look at 9091B, which talks of the MPC, which talks about the governing body's jurisdiction, and compare it to what the zoning hearing board's jurisdiction is, it's the zoning hearing board that decides the zoning issues, not the governing body as part of the subdivision process. And
well, I don't disagree with you, but that's why you need saldo approval and zoning approval. But the zoning issues are usually identified and vetted out during the saldo process. And again, I think you're complicating this by even looking at the saldo. The real question is whether the zoning hearing board has within its power to look at a use permit application that the zoning officer granted and say, we're granting it, we're denying it, or we're granting it with conditions. To me, those are the three things that zoning hearing boards do all the time.
And I take the point about saldo, and how I respond to Justice Donahue on that point is the saldo is not part of this case. There's no indication in the record anywhere from UPMC about what they're going to do next or how they're going to fix this stuff in saldo or anything like that. They didn't make it part of the record. So the zoning hearing board was sitting there looking at proven violations of the zoning ordinance and saying, we're not giving you a permit. The zoning hearing board had nothing in front of it, no record at all about what was potentially going to happen down the road.
Wasn't the zoning hearing board jumping the gun? I mean, weren't they expanding this thing from something the zoning officer had contemplated would occur at a later stage? In other words, wouldn't they have properly limited themselves to review of what he did and not expanded their review to these categories? I think there were 4 of them that he said, here are the caveats, you're going to have to deal with these later. Call them saldo or whatever you want to
the zoning hearing board's scope of review is not and cannot be circumscribed by the zoning officer. It's determined by what the challenge is. So the residents raise a challenge and say the zoning officer should have looked at these things, and if he didn't, if you, zoning board, agree with us residents that he should have looked at these things, then you should look at them. And they can be the basis for your decision not to grant the permit to UPMC. And that's what the zoning hearing board did. They took evidence. They gave everybody an opportunity to present their evidence as to why or why not the application complied. They made factual findings, and they issued their opinion. The other point about this notion of the application being a use application or something else, 2 points about that. Number one, the board did make a factual finding that has never been challenged by UPMC, that UPMC was not seeking there was no indication that UPMC was seeking something narrow like a use permit. That's a factual finding by the board. I think it's factual finding number 24 in the board's decision. The other part of that, if you look at UPMC's application and say, well, this is just asking the question of, is a medical center allowed in the office park district? It's reading the entire application process to be superfluous, and it's giving the board an impossible or an indecipherable job. The ordinance requires a zoning permit applicant to submit an application that lists the proposed use and such other information as is necessary to allow the zoning officer to determine if the actual proposed use, as contemplated by UPMC, complies with the zoning ordinance.
But is there any reason that can't be bifurcated, that the use decision by the zoning officer can't be a preliminary step? Is there any reason why it can't go that way?
Yes, because the application doesn't comply with the ordinance, and the Jefferson Hill zoning ordinance says you shall not issue a permit except in compliance with the provision of this ordinance. So it's the resident's position that if you have a non-compliant application, you don't get the permit.
Would consolidating the parcels alleviate all the zoning problems, or is it your position that only the Jefferson Hospital fits the definition of medical center within the relevant ordinance?
So consolidation is not an issue in this case because there's no record about any consolidation application, but it would not fix the zoning issues. I'll give you an example. One of the zoning problems is that, well, the property is 5 separate lots and 3 separate zoning districts within the property. In that if you put all 5 lots together, UPMC is still proposing an access road to support their medical center use with a gate that's on residential property. It was proven at the hearing found by the board that that gate, that road, is an accessory use to the medical center use, which is not permitted on the residential property. So even if you mushed all 5 of these lots into one lot, you still have 3 zoning districts, and it's still non-compliant with the zoning ordinance.
But on the non-compliance thing, I completely understand your argument that the zoning hearing board cannot approve something that is not compliant with the zoning ordinance. But zoning hearing boards all the time approve zoning applications conditioned on certain things. And those certain things may be to prove compliance with this provision when you go to do the access route, to prove the compliance, to get lot consolidation, to do this, to do that, to do this, to do that. That is compliant with the zoning ordinance because it's a conditioned approval conditioned upon you meeting the other requirements of the ordinance. That type of approval is not a violation of the zoning ordinance.
Whether it is or not, it wouldn't.
It didn't happen here.
Issue in this case.
It didn't happen here.
The issue is really, as I think you identified earlier, it's like, can the board do something or can it do something else?
Right. The UPMC's position is they had to give us the use permit. They had no other choice.
Right. I think that would be UPMC's position. And the problem is, to get back to the point about the application, if you look at and say that the only thing that the board could do, if you take the Commonwealth Court's view and say the board must have granted this use permit, what you're telling this board is that they should have stopped looking at UPMC's permit application on the first page. The first page of their application says medical center and office park district. The rest of it is plans, right? It's specifications and shows the lot lines and the setbacks and other things from the zoning ordinance, ostensibly for the purpose of allowing the zoning officer and the zoning hearing board to decide whether it's compliant with the zoning ordinance. The Commonwealth Court decision is problematic because it's telling the Jefferson Hills Board that your legal error, your mistake, was looking at pages 2, 3, 4, 5, and 6. If it's saying the only thing that you were allowed to do is look at whether medical center is listed in the office park district, I don't think boards know what they're supposed to do now, if that's the case.
Doesn't this, forget about the Commonwealth Court opinion for a minute. I mean, the zoning board concluded that the zoning officer lacked authority to issue a permit on a use-only basis. And then they took off from there. I don't see that as part of the operational background for what the zoning officer can do. It seems to me the zoning officer can, in fact, issue a permit on a use-only basis with the conditions that they attached here. So, I mean, was the zoning board correct that the zoning officer lacked authority to issue such a permit on a use-only basis?
We believe the zoning board was correct on that, but even if this gets back to the point earlier, even if you could find a way to say that the zoning officer could do what he did, it's not the question that's before this court. The question is,
because what's before this court is how this case got here, and the zoning board's decision was based upon its conclusion of law that the zoning officer lacked the authority to issue a permit on a use-only basis.
and its interpretation of the ordinance as.
They got to that interpretation because they came to the conclusion that the zoning officer didn't have the authority to do what the zoning officer did here.
And that's part of why they came to their conclusion. They also came to their conclusion based on a factual finding that UPMC wasn't seeking just this use permit. That there was no indication that that UPMC was trying to slice and dice this process up. So the zoning hearing board, again, is sitting there with their ordinance, and
UPMC did file an application for the whole banana. Okay, couldn't the zoning officer say, "I'm not going to go that far. I'm going to decide the issue, which is the predicate issue, whether or not this is a permitted use, and I'm going to say that it is. But nothing else is going to happen on this property until all of the potential zoning violations are worked out. And if that doesn't happen within what it is a year's period of time, the use permit expires."
well,
I don't know why that is an unreasonable conclusion, even if UPMC requested 100% approval.
the way the Jefferson Hills ordinance is written and what our position is that no permit of any kind shall be issued except in compliance with the provisions. And provisions is plural, it means all the provisions. So the view, that what our position is, and I think what the board's position was, which is correct, is that compliance with the zoning ordinance in Jefferson Hills is a condition precedent to getting the permit. It's not subsequent. So there's no provision in the ordinance to allow the zoning officer to issue a permit conditioned on subsequent compliance.
Well, that's the problem you're running into is these zoning approvals are granted with conditions all the time. And those conditions are often reviewed by the Commonwealth Court or by the Courts of Common Pleas first and then the Commonwealth Court for reasonableess. They're usually challenged. I mean, you're basically saying you're challenging conditional approvals. You're saying you can never issue a conditioned approval.
We're saying you get your permit if you comply with the ordinance. We're not saying every curb and sewer and light has to be exactly where it is.
Conditional approvals can include zoning. Conditional approvals can include zoning. They can include lot consolidation. They can include a whole bunch of things, not just compliance with the saldo, but also future compliance with the zoning ordinances.
I think that's not the way that the Jefferson Hills particular section is written.
Well, I might disagree with you too, because I don't think Jefferson Hills ordinance is anything special compared to other zoning ordinances throughout the state.
And in any event, it still gets back to what the board's decision was, which was the board's review is de novo of what the zoning officer did. The zoning officer.
Well, it's. Let me help you a little bit. It's even greater than de novo, because the board is hearing evidence and challenges and things that the zoning officer doesn't even get to hear.
Correct. And it has participants that aren't participants
that have rights to appeal
in the application process, right? So it's necessarily so that the zoning hearing board does more than the zoning officer, because the zoning hearing board has more power. It has objectors that can come and participate. If the objector's challenge can't be limited by just what UPMC and the zoning officer chose to talk about when they were going over the application, they have protections and rights too. And that's all they tried to avail themselves of here is, look, we have a zoning permit application. It's got violations of the ordinance. We're not in favor of this development. And we ask you, zoning hearing board, to overturn the issuance of the permit.
Okay, Mr. Stewart, I think we understand your position.
Thank you.
Let's hear from Mr. AUUE.
Good morning. May it please the court, my name is Tom AUUE. I represent AUUE Inc. Here with me today is Peter St. Tian Wolf from the firm of Petrogallo, Gordon, Alfano, Bosick, and Raspanti.
And AUUE is a wholly owned subsidiary of UPMC.
That is correct. So the process that was followed by the appellee here is a standard customary process, but it's also one founded in the law, in the ordinance, and in all the documents that told AUUE how to proceed, how to file an application. This wasn't a step outside of the ordinary. It wasn't an effort to circumvent any process. It was to comply fully with the requirements of the zoning ordinance, which are consistent with the municipality's planning code. The devil's in the details. There's a section of the zoning ordinance, 1202.1, specifically requires that no structure shall be erected until zoning approval has been issued by the zoning officer. First step, you have to get zoning approval. There was a question asked by Justice Brobson, is the use permitted? Why was it even needed? It took 4 years to have a determination that a use by right was allowed under a zoning ordinance for this hospital use. So inherently in the process is the fact that others can challenge it and delay. So the normal process is you get your use approved first, ostensibly the simplest approval, and then you go through the more complex and detailed and costly process of getting subdivision and land development approval. And then when you get that approval, you even go for the more costly building permit process, where you start getting into the minutia. It starts with the big picture, the use, and it eventually ends with the minutia of how do you build your building.
Because there would be no point in going through any of that if you weren't able to know you had the use permit.
That's exactly right. Now, why do you have issues that cannot be addressed at the same time? Because the municipality's planning code gives you different processes to get your ultimate end use approved. You go through a zoning process to get your use approved. You go through a land development process to get your land development. Now, is it inherent that one has to occur before the other? No. In fact, the cases that I've cited indicate that only if the subdivision and land development ordinance requires one to go first do you have to follow that process. But what we have here is a zoning ordinance that says you get your use first. But it also contemplates.
Where does it say you get your use first?
It says no structure shall be erected.
Are you about to erect a structure?
Well, eventually that's the goal.
I know, but you can't do that until you have saldo approval.
That's correct.
So there's nothing in the ordinance that says you couldn't go through the saldo process and then get your final zoning approval.
There isn't justice, but there is a provision in 701.8 that says, and we're in the OP district, uses in the OP district shall be subject to approval of a land development plan if required by the Borough of Jefferson Hills subdivision and land development plan.
Yeah, I'm just pointing out that I respectfully disagree. I agree with your point that there's no order that you have to go in. I respectfully disagree with your point that an ordinance required you to get something called a use permit before going through the saldo process. I think it's a good practice.
It makes sense.
It makes sense. But I don't see anything in the ordinance that required you to do this. But I see why the lawyers for UPMC wanted to do it.
Correct. It requires you to get a use permit, and to follow the logical, practical process, you get your use permit, and then you go through the more detail. And the ordinance contemplates that you have to get land development. That's the one section I just cited. And also section 1202.6 talks about the revocation of the permit, that if you don't comply with all the conditions attached to a zoning approval, the permit can be revoked. So this is a process that necessarily has to be followed one way or the other. You have to get both. Now, what's the logical conclusion of the appellate's approach here? If PMC would have gone for land development approval first, you have to tell the tribunal, starts with the planning commission, goes to the governing body, this is my use. I want land development for this medical center. Well, the first objection is the use is not allowed in the district, so you don't get your land development approval because the use is not allowed. So one of the things you want to do practically is know your use is allowed, so when you go through the land development process, you have that understanding with the governing body that what you're doing is lawful under the zoning code.
I certainly don't disagree with the process that you tried to employ here. I don't think there's a question about the legality of what you tried to do. The question is, when it came to the zoning hearing board, was the zoning hearing board's only option to either, well, I guess your thing is their only option was to affirm, even though it's sort of a de novo review, affirm the zoning officer's grant of the use permit.
They could have granted they could have added additional conditions to the grant of the approval. I mean, it really comes down to their limited review, and the MPC calls for this, is you review decisions of the zoning officer in issuing permits.
Right, but it doesn't say what kind of deference you have to give. They're hearing challenges by neighbors and community members and organizations that are bringing forward evidence and a whole bunch. I mean, the zoning hearing board is the adjudicatory body. They're the ones that make the decision that gives people rights to appeal to the courts. And the question in this case, to me, the very narrow question is, what was the power of the zoning hearing board? Were they limited simply to deciding whether the zoning officer acted reasonably under the ordinance, or could they have considered all of the challenges raised by the third parties and decided, and maybe the zoning hearing board was wrong to say the zoning officer lacked the authority to grant a use permit, but could they have looked at everything and said, we're just going to do it differently. We're going to say this is too complex. We're not going to just give a use permit here. And by the way, we don't think you asked for that. We're just going to deny this because we're not convinced that this is going to ever meet zoning approval. Does the zoning hearing board lack the power to go that route?
It does, Your Honor. Fundamentally, and this was argued at the lower court level, this is an appeal from the decision to grant a use permit. The zoning officer testified that all he was doing was issuing an approval of the use, and that the other aspects that were being challenged would be the subject of further review based upon the conditions. I struggle to find a case, and I did a lot of this stuff in Commonwealth Court, that limits the zoning hearing board's review that way. To basically, because if that was really it, then you wouldn't need a record, right? You wouldn't have needed challengers. The only issue would have been, does the zoning ordinance allow this or doesn't it? And you don't need evidence for that. Well, that's what we argued from day one, that this is statutory statutory interpretation of a zoning ordinance for a use by right, and we didn't need 9 days of hearings to determine the use was allowed by right, and that it was inappropriate for the zoning hearing board to delve into all these broader matters.
Do you have a case that stands for that proposition that the zoning hearing board's review is cabined that narrowly?
I do not. I have the MPC that says what the subject of an appeal to the zoning hearing board should be, and it says appeals from the determination of a zoning officer, including but not limited to the granting or denial of any permit. So if the permit is only for the use and the subject of the appeal is the approval of that use, it follows that the zoning hearing board should only be looking at that very matter.
But could the zoning hearing board, could the zoning officer have denied your use permit?
Yes.
And said, so could the zoning hearing officer approved your use permit with conditions?
Yes.
Could the zoning hearing board have denied it, or the zoning officer have denied it?
Yes.
Okay, so you're basically saying then, under the zoning ordinance and the MPC, the zoning hearing board reviews the determination of the zoning officer for an abuse of discretion. And if the zoning officer was allowed to do these things, the zoning hearing board can't do anything about it.
Well, that is correct. And if it had been denied, then it would have been AUUE filing the appeal to the zoning hearing board saying we have a use by right and we can't get it approved for a zoning permit. And then at that point in time, does that appeal then entitle objectors to raise all these other ancillary issues that would be addressed at a land development stage? You know, my position here before this court is it does not. We have to follow that logical process of how you address issues at the proper time. And fundamentally, there was a question raised, does a consolidation plan address all these issues? It does. Does a land development approval address the issues? It does. The comment was made by opposing counsel that there's this private access road. It's an emergency access road that is proposed.
Counsel, share with us, based upon your position, how do you distinguish your position from Bethlehem Manor, the 2021 Commonwealth Court case?
Your Honor, I am not specifically familiar with the Bethlehem Manor case.
Let me just share with you, the Commonwealth Court in 21, the ruling is a zoning hearing board, even sitting in its appellate capacity, is not to engage in a narrow review of the zoning officer's decision based only on the materials offered to the zoning officer, but is required to make findings based upon proceedings conducted before the zoning hearing board. In essence, what Justice Robson's been saying seems to conflict with your position.
But if the issue that is before the board is only the initial narrow issue and it starts delving into matters that will be addressed in subsequent appeals or application processes, such as the subdivision and land development approval, it gives the zoning hearing board the ability to jump the gun. They get to rule on something before it has been vetted before the proper tribunal. And that tribunal here would be the land development approval that goes through the Planning Commission to the governing body.
Maybe this is one of those things where I feel like I probably know too much. The SALDO process does not result in zoning approval.
It does not. But it addresses these issues that have been raised in this case, and there is a condition when the use was approved that you have to satisfy these other requirements.
And when SALDO approval is given, there's also a condition that you have to comply with the zoning ordinance and get zoning approval.
Absolutely, and a party has the right to appeal the SALDO approval.
But this is sort of a chicken and egg.
It is
thing.
exactly a chicken and egg.
And the problem that I'm having, and I keep going back to, is who gets to determine which goes first. And your position is that the zoning officer gets to determine which goes first. And the MPC or the zoning ordinance confirms your view that the zoning officer gets to make the zoning officer and UPMC get to make that decision. The decision, the appellant's position is no. The zoning hearing board makes that decision. The zoning hearing board certainly could have done exactly what the zoning officer did. But the question is whether the zoning hearing board was prohibited from saying, you know, there's too many wheels going on here. We're not ready to bless this until certain things are fleshed out further. You're saying they could not do that.
Not when, especially, there are conditions that are imposed upon the approval of the use that specifically require that for the use to take place. And I don't want everyone to lose sight of what this approval is. It doesn't say you get to have your development. It doesn't say you get to build your building. It just says your use as a medical center is allowed. And there's a whole plethora of processes that you need to go through to complete that process to be able to put a shovel in the ground. If you want to make
it's an eminently reasonable position. It's just the question of the power of the zoning hearing board. I think that's what this case comes down to.
And the practical ramifications are, though, that you quell development across the Commonwealth if you force parties to simultaneously comply with all land use provisions that allow a party to develop and use a parcel of real estate. I mean, there's more than subdivision and land development. As you are aware, when you get SALDO approval, it's conditioned on HOP approval, stormwater management approval. There's any number of additional approvals. If they all have to be concurrent and occur at the same time and get approved at the same time, practically you end the way property is developed in the Commonwealth and the way it has been developed since I've been practicing law. And that,
can I ask a more practical reason? Let's assume that what the zoning hearing officer did in this case was approved up the line. When would the residents of the borough of Jefferson Hills have their opportunity to be heard on these zoning issues?
they would have the opportunity to come during the subdivision and land development process when a consolidation plan is being filed. That, I think, would address the very issues.
And then the decision at that stage would then be appealable?
It is, to the same process. It's a statutory appeal.
That process bypasses the zoning hearing board.
It does bypass the zoning hearing board. Now, it's common that a land development approval process might be predicated upon the need for a variance, not here, and then it would make it conditioned on going before the zoning hearing board. The conditioning of this dual process goes back and forth and has always existed. Now, the question was asked, like, what dictates what process you follow first? You know, there are cases that I've cited, and it's in Ray Smith, and it says the order of the dole tracts. That's the argument we've made. There's a dole tract process. The courts have supported and recognized and acknowledged subdivision and land development as one tract and zoning approval as the other. It says the order of these dole tracts is based upon the subdivision and land development ordinance. And in this case, the borough's ordinance was silent as to what tract should proceed first, and as a result, it gave the opportunity for UPMC to choose what is probably the most fundamental, is the use allowed before you incur the great expense to seek land development approval.
Okay, I think we understand. Are there any other questions for
I just
council?
have one comment,
Sure.
Chief. I just wanted to give a kudos to the appellant's preparation of their brief in this matter. It included within the body of the brief various schematic plans of this proposed development, and it was just very helpful, I found, when I was reading it, to have the picture there instead of having to try to dig through a record for it. So thank you.
And may I say that both of you have managed to accomplish something that I thought was nearly impossible, and that is to make a zoning case interesting. Thank you both.
Thank you for your
I've
time.
been trying to tell the justices for a year and a half that they're very interesting.
Would you call the next case, Mr. Minner?
Beverly Ferraro versus Patterson-Erie Corporation, and this is Burger King, representing Patterson-Erie, representing Ms. Ferraro, Mr. Ryan Clary.
This appeal presents the issue of whether the plaintiff demonstrated a good faith effort to effectuate service of her personal injury complaint on the defendant. She requested the sheriff serve the complaint in accordance with our rules of civil procedure, but for unknown reasons, the sheriff did not do so and did not give the plaintiff notice of the failure to serve. Upon learning that service was not effectuated, The plaintiff hired a private process server who served the defendant within the statute of limitations. Then, 10 weeks after the limitations period expired, the plaintiff reinstated her complaint and the sheriff successfully served it. The defendant moved for judgment on the pleadings, contending that the complaint was barred by the statute of limitations, which the trial court denied. The Superior Court affirmed, holding that the plaintiff made a good faith effort to timely serve her complaint, that she did not have an intent to stall the judicial machinery, and that the defendant was not prejudiced as it received actual notice of the complaint within the statute of limitations period. We accepted appeal to review the lower court's determination. Good morning.
Good morning. Madam Chief Justice, and may it please the court. My name is Aaron Weiss. I am with the law firm of Zimmer Coons, and I represent the Aplt PEC Management. There are 5 key facts to consider when evaluating this case. First, appellee never attempted to serve her complaint within that first 30-day requisite period. Second, all other plaintiffs in the same county and at the same time were able to do so properly via the sheriff.
But why is that her fault? If the sheriff messed up in this one instance, why does that divest her of her if she otherwise showed a good faith effort?
Well, Your Honor, I think that is the point, is whose duty is it? And under the law, and under the seminal case of Gussum, the plaintiff has the duty not only to file the complaint, but to ensure that there is service. So if she does nothing more, as she admits, than placing the complaint and a check in the mail, does that just end her duty and she's fulfilled good faith, or does she have a duty to ensure that it actually does get received by the sheriff and an attempt at service is
Well, wouldn't that mean that every single case would go your way if the service wasn't effectuated? Doesn't that devour the whole good faith exception or good faith principle?
Not necessarily, Your Honor. It depends on the facts and circumstances of the case, as this court held in McCreesh. If you have an example where there is a plaintiff who makes a admittedly technically deficient but good faith effort to serve and to actually effect that notice within that first 30-day time frame, then there can be a leniency in that case-by-case analysis. But here, to take a step back, again, the very first point in this is that there was no attempt at service within that requisite 30-day time frame, which is required under Rule 401A. In McCreesh, there was service the very next day after the complaint was served. So I think
the reason for that is because after 30 days, you no longer have a live process. You don't have a live complaint. Am I correct?
You're exactly.
After 30 days, if you don't reinstate the complaint or reissue the writ, you are serving a piece of paper.
Exactly.
Serving process. And that's why that 30-day period is important. There is no reissuance of this complaint, reinstatement of this complaint, even when it was served by a private process server.
Exactly, Your Honor.
So this isn't a question of overlooking failure of service by the sheriff within 30 days. This is overlooking failure to comply with the rules of civil procedure that require reinstatement of the complaint.
That is exactly correct, Your Honor.
Well, let me ask you this. Is it possible to view the sheriff's failure to serve, since the sheriff's duties are enmeshed in the judicial system, as a breakdown in the mechanics of the judicial system?
I don't believe so, Your Honor. And that was what the, I believe, Superior Court was hinting at when they, sua sponte, referenced the Bradford opinion.
Right.
And there, the difference was it was the court itself that was supposed to mail something in, and that was never done. Here, we have the exact opposite. It's the burden on the plaintiff to ensure that service is fulfilled. That's established in Rules 400 and 401. So the plaintiff's burden, although they initiate it by by filing the complaint, it is not complete until service.
So she can't rely on the sheriff?
She has to ensure that she takes any additional necessary steps to ensure that the sheriff actually does that service. And we see that established in the case law.
Counsel, can I just this couple of points that were made about the sheriff failing to serve? Is there any evidence that the sheriff ever got the service letter, the request? Is there proof of mailing? Is there anything that suggests the sheriff somehow failed to do anything?
None at all, Your Honor. And in fact, I would argue that under the record at 324 through 328, in fact, every other plaintiff in the same county at the same time who did get their complaint to the sheriff properly, it was served within that 30 days.
There's no evidence in the record that the sheriff failed.
None at all, Your Honor.
Let's change that to it was not served by the sheriff.
It was not, Your Honor. But again, my primary point is that when does the duty for the plaintiff end? And the plaintiff has the obligation under Rules 400 and 401. And to begin, we see in the Englert opinion by the Pennsylvania Superior Court that there is more of a duty than just mailing a copy of the complaint to the sheriff. You can't hope that it gets there, assume that it'll be served, and just sit back and rely on the sheriff to do so. And in fact, as I quote, the contention that the filing of a precipice and delivery of the writ one time is all the law requires is quite simply contrary to the case law in this Commonwealth. That is a decision that was post the McCreesh opinion by this honorable court, and again supports that although you initiate the process of service by filing, you, the plaintiff, have the obligation to fulfill that. And by simply mailing something or placing it in the mail, hoping it gets there, hoping it gets served, without ever checking the docket, calling the sheriff, ensuring that it's done timely, belies a good faith effort.
Well, even assuming part of your sentence there was valid, correct, at the end where you said belies a good faith effort, does the fact that that the private process server was sent and successfully provided the papers, and that there was actual notice and there was a litigation hold, and that the carrier completed an investigation and all these other things were going forward, does that militate against your position that there was no good faith effort here? Or is that an alternative argument, or what?
It does not, Your Honor. And I believe the plaintiff's argument is essentially, first, the fact that she mailed it sufficed her good faith effort, which we do not believe it does for the reasons that we just set forth. But then her backup argument is that even if we didn't make a good faith effort just by that mailing and complaint, then our untimely private process server and actual notice should suffice. So I think those are her two arguments. And to directly answer your question, that is insufficient based on the law.
Now, so what good faith are we looking for? Good faith to comply with the rules of civil procedure?
Exactly, Your Honor. The good faith standard is to make a diligent effort to comply with Rules 400 and 401.
Okay, so the process server is giving a piece of paper.
Exactly, Your Honor.
The complaint was never reinstated.
Correct, Your Honor.
There's plenty of time. There is a live statute of limitations. I would have a totally different view of this if we were looking at, 28 days before the statute expires and things of that nature. This was just a complete ignoring of the requirements of the rules of civil procedure.
You're exactly right, Your Honor. First of all, there was no action whatsoever taken within that first 63 days. After the complaint was mailed, or on March 4th it was filed, it was mailed allegedly to the sheriff. Nothing happens for 63 days. At that point in time, 63 days later in May, had the plaintiff simply precipied to reinstate the complaint and had it served via the sheriff, it would or should have been done. Because as we know from the record, the sheriff was serving in Butler County, at that time. But instead of taking the legitimate and rules of civil procedure processes in place by this honorable court, instead they chose to circumvent and disregard those by hiring a private process service that was admittedly an incorrect procedure to take. And when I say the term admittedly, I'm referring specifically to the record at page 320, where in the lower court at the trial level, Aplt conceded that she, and I quote, has never argued this doesn't need to be taken care of by original process. We are not attempting to supplant the sheriff with a private process server. So by her own admission, all she is doing 63 days after the initiation of this lawsuit is giving an actual notice, which is untimely, and which is furthermore not in compliance with the rules of civil procedure established by this honorable court.
I guess my question to you is, we have these rules so that a court can acquire personal jurisdiction over a defendant in this Commonwealth. And so, without complying with either of the two rules, when you have plenty of time to do that, are you creating a situation where we would encourage people just to ignore the rules?
Your Honor, that's 100% accurate. And that was one of the primary arguments in our brief, was that allowing a case such as this to proceed would entirely erode the sheriff service requirement in this Commonwealth that was not only established by this court, but was upheld in 1985 when it reestablished specifically that it is the sheriff that has to serve in this Commonwealth. What I'm referring to is the preemptory comment to the Rule 400 in 1985, where they specifically discussed whether or not someone other than the sheriff, like a private process server, could do so. At federal court, for example, that's perfectly fine. This court chose not to adopt that reasoning. And so not only because it wasn't the sheriff, but also because it was not timely within that 30 days, then for both of those reasons, either independently, this case can and must be dismissed.
Well, I mean, this is a red herring. This private process server is a red herring here. I mean, there was a complaint that was dead. Mm-hmm. I mean, this plaintiff could have put it in ordinary mail.
Right.
And said, I gave actual notice.
Right. And that's precisely what we've argued, is if this case is permitted to proceed, not only can that happen, that is what's happening. We cited in our reply brief in Appendix A, because there were decisions from preliminary objection rulings at lower courts, I believe in Westmoreland County just last year in 2022, that despite the fact that Appellee's counsel in this case is claiming this was a one-time good faith effort, in fact, they're continuing this same procedure of using private process service throughout this Commonwealth, even last year.
Well, that's clearly improper. I mean, there's no question that service was improper, but it's always been the case in these cases that we've taken, McCreesh, Gussum, and all these other cases, that there was something improper. Otherwise, they wouldn't come up to us, right? But the standard set forth in Gussum was improper but diligent attempts at service. So for you to win, we have to find or conclude, don't we, that attempts were not diligent. Would you agree with that?
I do agree with that.
Because we said in Gussum that her improper but diligent attempts at service resulted in the defendant receiving actual notice, and that was fine unless plaintiff's failure evinced an intent to stall. And you haven't maintained that they intended to stall.
Right. My intent is that we never get to that issue because first it is plaintiff's preliminary burden as set forth and reiterated in Gussum by the late Justice Baer.
Did we consider the fact that this was at the beginning of the pandemic in any way?
Not at all, Your Honor. And there's a couple reasons for that. Number one, it is a red herring issue because, again, every other plaintiff in that county at the same time, as supported by the record on those pages 324 through 328, were able to serve properly. Second,
and there's no evidence that the sheriff's office actually received her papers.
None at all. And again, it is the plaintiff's burden to set forth that. So if they would show a certified mail with proof of receipt or proof that the check that they allegedly sent was cashed, that would support their good faith effort.
Right.
But
and
again,
they never got the return of service from the sheriff.
No, certainly not. Because again, the sheriff...
That alerts you that maybe something's wrong.
Exactly. And you have to do something more than just wait 63 days before you inquire, why is mine not getting served, especially when I can see publicly that everybody else's is.
But I mean, the 63 days is interesting, but I think the more interesting time frame is 113 days after the 63 days.
I agree. Right? Either one's fine.
63 days. I mean, and this is a little different than Gussum, and I'm terrible with case names. I tell my clerks this all the time. But I think Gussum was the Philadelphia case where the Philadelphia rule of service is a little bit different than everywhere else.
McCreesh.
Okay, McCreesh. Okay, so McCreesh was a little different. The argument was the lawyer actually thought using a private process server or a private individual was fine. So there was at least a arguable diligent effort to comply with the rules. Your argument here is that this is not a technical misstep. This wasn't her trying to comply with service. This was her just not trying to comply with service for 113 days.
Right. Not only is it an intentional circumvention of the requirement of the sheriff, but also a significant difference in that McCreesh opinion was, again, that was served 1 day later. So it's not dead, as Justice Donahue pointed out at that point in time. It's very much alive. Here, everybody knows 63 days later it is dead.
But she could have. I think the reinstatement point that Justice Donahue made is a good point. I guess I'm going 63 days later, she learns somehow, some way that the sheriff has not served this. Mm-hmm. Regardless of whether she should or should not have reinstated the complaint at the point, I think she should have. But she didn't try to serve by sheriff again. And she had plenty of time to serve by sheriff again. She just decided, I'm going to go some other way, which is not what was happening to McCreesh.
Absolutely, Your Honor. And again, I refer the court to that record at 320 where she admits that she knew her use of private process was improper. So you're 100% correct on that.
And not to be a stickler about this reinstating the complaint, plaintiff in this case at some point in time believed that that was an essential prerequisite for continuing this action because they in fact reinstated the complaint after the statute of limitations passed.
And, Your Honor, as I cited in footnote 6, I think that even further supports her own knowledge that what she had done up to that point in time did not effectuate service. Because if it did, or if she truly believed that she had properly served, why not, as of June of 2020, filed a 10-day notice and said, hey, I served you?
You're misstating what's going on here, though. There was never a thought that there was proper service here.
Right. Right.
There was never a thought that there was proper service here.
Agreed.
Either by virtue of using the sheriff the second time around or reinstating the complaint when you attempted service by a service of process.
Yes, I apologize. My point was if she had truly thought that, exactly as Your Honor pointed out, then she wouldn't have reinstated it at some point in time, which confirms that then.
And if you're going to claim you've made a good faith effort, don't you have to be able to assert that I believe that I complied with the rules?
Yes, Your Honor.
Okay.
That is correct. And as Your Honor pointed out, and the case law from this very court in Cintas in 1997, that service has to be strictly followed and is not merely a procedural defect that can be ignored, which I think and hope.
That's the personal jurisdiction.
Exactly.
Issue.
And I think and
why
hope.
Why we do all of this.
Right. Why this court would be here today. Your Honor, it should not drive a different result, and here's why. When Justice Baer was considering, he wrote the opinion of both McCreesh and Gussom, and as he explained, he even was concerned that McCreesh could be misinterpreted in a way to suggest that any notice, actual notice by any means would be okay, and therefore he specifically put in Gussom at page 1056, like Farinacci, McCreesh did nothing to modify a plaintiff's duty to act diligently to serve notice. Nor, for that matter, did McCreesh change the rule clarified in Farinacci that the plaintiff carries the evidentiary burden to prove she made that good faith effort. So Gussom, all it does is provide further support, putting McCreesh in line with the long line of 50 years of cases set forth by this honorable court. Farinacci, Lamp, Witherspoon, which, by the way, Witherspoon, I think, is probably the most factually accurate to what we have here, which is a case where there was just one alleged attempted service and then nothing for an additional 9 months. And here we have about an 8-month delay between the filing of the complaint and then ultimately that reinstatement, which occurs 69 days after the passing of the statute of limitations and 271 days after the complaint had been served. So again, we are talking about that good faith diligence standard that Justice Wecht hinted at, and diligence was discussed 8 times.
Is it the good faith standard in following the rules of civil practice, I think Justice Donahue said this, or was it, as they say in Ferraro, is it the good faith effort to notify a defendant of the pending action?
It is absolutely the good faith effort to comply with the rules of civil procedure, and here's why.
That's not what Ferraro says.
Your Honor, Ferraro states that you have to comply with local rules and procedure in order to ensure that that service is effected. Service is not the same thing as notice. And if we hold otherwise, it relegates Rules 400 and 401 to mere surplusage. If all we have to do is notify someone that there's a lawsuit against them, then not only does it eliminate those two rules, but to bring up Justice Bayer's prior hypothetical in the oral argument, you could send a letter to someone, tell them they've been sued, go on a year-long cruise. And under that standard, that would be okay if all that's required is actual notice. And for that reason, actual notice cannot serve as a shortcut to circumvent and disregard the rules of civil procedure. One last significant point, and again, just to highlight that this matters significantly more than just this case, is again the fact that if this case and the improper service and the untimely service and use of private process just to give actual notice is sufficient to stand, then no one will have to comply with Rules 400 and 401 in this Commonwealth. And to specifically address that point, this counsel, or this appellee's counsel, has continued, and we have set forth evidence via the Appendix A to our reply brief that they are continuing to do so. So if this court does not reverse the error by the lower courts, then they will continue to use that private process, get actual notice, and then that will end any argument that it hasn't been properly served. If this court wants to get rid of sheriff service, then it is okay to do so if it wants to amend those rules of civil procedure.
This was an unpublished Superior Court opinion with no precedential value.
Your Honor, that is true for this case below, but we're here before Your Honors, and if it's not corrected, we're already seeing that the practical effect is that people are continuing to do this method of just service and, or excuse me, not service, notice by any means and circumvention of the rules of civil procedure that were not only set forth by this court, but confirmed by this court as being the only way in this Commonwealth to serve.
Okay, I think we understand your position. Any other questions?
I have one other question. Let's talk again about reinstating the complaint. What's your view of the reason that we have that requirement within our rules?
Your Honor, the reason to reinstate the complaint,
yes.
I think it is to ensure that the plaintiff is doing their due diligence to ensure that they're keeping the process of the judiciary moving. If it's been 30 days and the sheriff hasn't served, then we need to make sure why hasn't the sheriff served? Is it some issue, and can we get it fixed? That's why I personally think it occurred, or why the rule occurred. But more importantly, frankly, it doesn't matter, in my opinion, why it's there. It is the rule. And
well, it's there, isn't it there also because the court is a player here? We need to know when there are active lawsuits in our courts, and if it's not reinstated, then, as Justice Donahue said earlier, it's just a piece of paper.
Yes, Your Honor, that is correct.
And when the defendant is served with a complaint that no longer says complaint, but it says reinstated complaint, the defendant then knows that the claims are not stale. They are claims currently being asserted pursuant to the reinstated complaint.
Correct, Your Honor.
I mean, maybe the rule's an anachronism. I mean, I don't happen to think so, but, you know, the fact of the matter is that it's a rule.
Correct, Your Honor. And I think another point, again, to emphasize not only the reinstatement, but the sheriff is then handing someone in uniform a piece of paper that says, hey, this is significant. You need to do something about this. And again, that's not what occurred here.
I mean, we keep talking about the rule, but everybody knows the rule was broken here. I mean, this question of whether your client knew the complaint was stale or not, or it seems to ignore the fact that you have this litigation hold, the carrier's on notice. I mean, you folks knew there was a live case here, right? I mean, so I'm not sure about this stale theory.
Your Honor,
in your case?
the record, and I apologize for cutting you off, the record at page 91 confirms that what was discussed before was pre-suit information, and the carrier denied liability. So it's not like there's ongoing settlement discussions or issues as to the case. They're told there's an incident. They say, we're not liable. That's the last notice that they have. And furthermore, there is a slew of case law that simple notice to either the insurer or pre-suit claims are insufficient. Moses, the Superior Court in 1999, or actually most recently, the Seneca opinion from the Superior Court in 2023 confirmed that as well. But it harps back to the distinction between notice and service, and the rules require service.
Thank you, Mr. Weiss. Let's hear from Mr. Flaherty.
Thank you, Chief Justice. May it please the Court. Ryan Flaherty from Simon.
Lift the microphone.
Of course. Ryan Flaherty from Simon & Simon on behalf of the plaintiff, Beverly Ferraro. The case law in this matter has been settled since 2005 in the McCreesh matter, and then it was affirmed again in 2021 in the Gussum matter. Gussum added no additional requirements, but affirmed the rationale of McCreesh, which adopted expressly a more flexible approach at service when a timely filing occurs and a good faith effort at service, not a good faith effort, as has been forwarded, to comply precisely with the rules of civil procedure. That was expressly diverted from that.
Service is a technical word under the rules of civil procedure. It's not, you can't divorce it from the requirements of service. It doesn't say, our case law does not say good faith effort at giving the defendant notice. It says good faith effort at service.
I agree.
And it also says we'll forgive technical missteps. But the counsel in this case, in my view, didn't do a technical misstep. The counsel in this case ignored the rule and went with a private process server when they had every opportunity to go back to the sheriff or go to the sheriff in the first instance if they didn't get there correctly the first time.
And I would indicate that that only occurred as a backup situation when it became clear that the sheriff was not serving the complaint.
Well, no, there's no evidence that the sheriff had the complaint.
There's evidence that the docket received it, and the docket received 2 certified copies to the sheriff, and the docket records the sheriff check of $73. And the docket also records that the prothonotary mailed certified mail of the assignment of Judge Yeager from this case to defendant 2 days after the filing was received. Plaintiff in this case took every usual and customary step to comply with the rules.
When I was in private practice, I handed it to the sheriff and got a timestamp back, so I never mailed it to the sheriff.
In March 2020, there needs to be some recognition that this was not operating as normal, and 2 days after the filing of this case,
why 113 days after you learn that the sheriff didn't serve for whatever reason, do you not try to get sheriff service during that period?
Out of an abundance of caution.
That's
when we did.
But you didn't do abundance of caution. You did alternative. You didn't go to the sheriff and give private process serving. You just went private process serving. You didn't try to do the sheriff.
The assumption in May 6th of 2020, was that the sheriff's office simply wasn't functioning. And it should be added that
what evidence was there that
it wasn't functioning? Is that what you
that
said?
was the assumption of the firm because no response was received. It is not unusual.
Where is the evidence in the record that that was the assumption of the firm? That the assumption of the firm was we went process server because we didn't think the sheriff's office was open.
That's what I'd written in the brief.
But there's no evidence of that. You didn't bring the sheriff in, and the sheriff didn't testify we were not operating. In fact, the evidence seems contrary, that the sheriff was serving.
It does seem that some complaints were served. It doesn't say anything about which ones weren't because we have no way of knowing that. I can't prove a negative to the court.
Well, and
So
we
what?
don't,
Why
we
not
don't
go
have
back to
any
the
of
sheriff?
I'm
So
sorry.
what? Why not go back to the sheriff?
We did eventually go back to the sheriff.
In November, after
Out of
the
an
statute
abundance
of
of
limitations. And you reinstated the complaint after the statute of limitations. When in May of 2020, you learned that the sheriff hadn't served, why not reinstate the complaint and go back to the sheriff?
That
you
was
had
an
plenty
option,
of time. You
but
had plenty of time.
At that time, we had assumed that the sheriff's office wasn't functioning normally.
Was there any evidence of that?
The evidence that we never received any affidavit of service or non-service in a response to our initial filing.
That's a big leap because we made every effort with the courts to make sure our courts were open for business throughout the pandemic, and I To my understanding, the sheriff's offices were as well.
It seems that they were, but at the time that was the rationale taken. And we knew we had timely filed the complaint, and we knew that we did every usual and customary step in the hundreds of complaints that are filed every year to engage the sheriff. That was met with silence, so extraordinary measures were taken, and we paid for an additional service step in a situation where we know the defendants already had actual notice, not only that a lawsuit was coming, but of a complaint of the facts and circumstances in this case.
Okay, I think we get the issue. More questions?
Why didn't you reinstate the complaint before you attempted service by a private process server?
Again, the rationale at the time was that it wasn't functioning normally.
It's the courts? You reinstate a complaint in the courts. You go to the court issues a new document, stamps it, called reinstated complaint.
The Justice is correct. I don't have an answer to that question.
Any other questions?
In Butler County, I mean, do you normally get a return of service from the sheriff?
We do, and I would add that it's not uncommon to receive the return of service, either affidavit of service or affidavit of non-service, weeks after your precipice or complaint has expired, and you're automatically reinstating at that point. It's not like on day 30 you get one way or the other. It may be day 45, day 60, day 70 when something comes back to you. Certainly in March or April or May of 2020, mail was not exactly on time as well. This needs to be viewed in the context that this was at the height of the pandemic when various public and private services were closed and shutting down and entrance orders.
The courts and the sheriff's offices were not closed down.
No, they did function for essential operations.
Yeah, I'm very uncomfortable with going your way, adopting this theory that the reason why you should have been entitled to ignore the rules was the courts and the sheriff were not functioning, in the absence of evidence that the courts and the sheriffs were not functioning.
Well, Justice, we didn't ignore the rules at the first service. We made a good faith effort at service, and that's what McCreesh. There are times when a sheriff does not serve, and when you don't get your return of service, which you found out, and you had 113 days left, the appropriate, or you could have called the sheriff's office. You just kind of decided, we're just not going to bother. We're going to hire a private process server. I'm struggling to see how that's not McCreesh. McCreesh was, the lawyer said, I actually thought I was complying with the rule of civil procedure. This one, you concede you didn't comply with the rule, and you concede that you intentionally chose to go with a private process server when you could have gone back to the sheriff. That's accurate, Justice. It's also accurate that the McCreesh holding does not require perfect diligence. It requires a good faith effort at service and compliance, which occurred 2 days after the filing.
Well, an interesting way of looking at, I think an interesting way of looking at it, at least, is that, assuming a good faith effort and no intent to stall, we still have the language from Gussum about diligence. And as I see it at this point, we need to assess diligence in deciding this case.
The Bradford case, which is alluded to by the Superior Court, doesn't indicate case law on diligence, that due diligence does not require perfection. Due diligence is a good faith standard, which is what the Ferraro Court interpreted.
Even if we buy that, what do we do with the fact that the complaint was never reinstated, or was not reinstated within the statute?
The jurisdiction is triggered by the timely filing which occurred here. Actual notice occurred as well, not only from before the timely filing, but when the Butler County Patterson-Erie copied the order of assigning Judge Yeager by certified mail to the defendant, which is part of the record. And then, after the statute was told, they received another copy of the complaint through process server. So I agree, there is a 30-day window where one is supposed to have the sheriff serve that. That was attempted, and it failed for reasons that the record cannot explain.
All right, but what was served through the process server was not actually a complaint.
It was a copy of the complaint.
But I mean, it wasn't the reinstated complaint.
Correct.
You had a complaint that was no longer alive.
I understand the first position.
All right, anything else? Thank you, counsel.
Thank you for your time.
We're going to take a short lunch break. Mr. Minner, we have 2 more cases that we'll hear at 12:30.
Trust B under agreement of Richard H. Wells, representing Aplt, V.M.I. Foundation, Mr. George Roberts Jr., representing PNC Bank, Ms. Margaret Sager, representing the Commonwealth, Mr. Anthony Aplt.
Good afternoon. In this appeal, a public charity filed a petition to terminate a charitable trust of which it is the sole beneficiary pursuant to the charitable trust termination statute. It sought to transfer the trust assets to itself outright, free of the trust, so that it could fulfill the settlor's charitable purposes unencumbered by expenses and burdens that arise from the trustee's administration of the trust. Both the trustee and the Attorney General, intervening as parens patriae, opposed termination, contending that the public charity failed to satisfy the statutory requisites for the trust termination. The trial court refused to terminate the trust, and the Superior Court affirmed. We granted review to interpret for the first time the charitable trust termination statute and to determine whether the lower courts properly applied it herein.
May it please the Court, Madam Chief Justice and members of the Court, I'm George Roberts, and I'm here on behalf of the V.M.I. Foundation, appearing pro hoc vice. I want to express my appreciation to the Court for the opportunity to appear before you today, and also express my appreciation to your staff. They're an incredibly very gracious group of people, and I've really appreciated
Thank you. We think so as well.
Comment with them. This is a unique statute. It's a unique case. It involves the interplay between the General Assembly, the Congress of the United States, in which the fundamental decision for the court will be focusing on what do the words in the statute mean when the separate existence of a trust established solely for charitable purposes result or will result in administrative expenses and other burdens unreasonably out of proportion to the charitable benefits. A starting point of this certainly should be the facts are not in dispute. Mr. Wells created a trust. It's very straightforward. It provides an income-only trust, a charitable gift, providing annual income to the V.M.I. Foundation, which exists to support higher education, and in particular, the V.M.I. the Virginia Military Institute. The charitable benefits are not defined. And we suggest, and the Attorney General, I believe, agrees, charitable benefits are different from your charitable purposes. They are the actual cash to be provided each year from the fund that Mr. Wells created. And those funds are then available for use in the support, unrestricted aid for supporting V.M.I. and the activities of the V.M.I. Foundation. So the case is centered around how will those benefits be determined? And it requires an examination of Mr. Wells' history, the history of a number of statutes in Pennsylvania, to include the Principal and Income Act, which has well-defined income, dividends, and interest. It requires us to examine the response of the General Assembly to the establishment by Congress in 1969, the year after Mr. Wells died, in an effort to force charities, which they then defined as private foundations, were going to now be required to make annual distributions to assure that their charitable purposes are being fulfilled. And thus, it creates this mandatory, established in 1976, 5% annual distribution requirement. It's fixed. It's not subject to averaging the asset base beyond 1 year. As a result, the Commonwealth responds as it needed to amend the existing trust to bring them into compliance with the requirements of the private foundation rules. They include this mandatory payout. They also include certain administrative restrictions on things like excess business holdings, self-dealings, that by statute you are required to have those as part of your governing documents. It responds in 1971, the acts adopted in December, private foundation statutes adopted in December of 1969. The General Assembly responds by the adoption of the Charitable Instruments Act in 1971. And it then provides that you can use principal to meet the annual 5% payout requirements. Mr. Wells' trust was very consistent with the patterns of trust documents in those days, in which income only was being distributed to the charity, and principal was to be kept intact. And your Principal and Income Act amends that, or codifies it, going back to, I think, to 1947. And so this 5% test required payout, and if you don't make it, there are serious penalties for underpaying. In an era, just as we've seen in the last decade or so, when interest and dividends were less than 2% a year, the Charitable Instruments Act cures that problem by allowing the use of principal to make up that difference. It also provides in the 5th section of the Act that courts retain the jurisdiction to order deviations from the terms of a trust. In 1972, if I get your legislative history right, we recodify your rules with respect to charitable trust gifts when we adopt the predecessor to the current trust termination statutes in 7940.3, in which we have 3 specific cases in which the General Assembly addressed changes in circumstances. Subsection A is your classic cypre. Subsection D is your small trust exemption, the only time the Attorney General and the trustee must agree that you would terminate the trust because it's not economical. And we have the trust termination statute, which is very strange in its language because it's not speaking to just a change in circumstances. It starts with if the separate existence, and separate compared to what? And it applies almost identically into this case because the separate existence in this case means that Mr. Wells' trust is a private foundation and is governed by the rules established by Congress. By contrast, the V.M.I. Foundation is not a private foundation. The statutory scheme is all 501c3 organizations start as private foundations unless you have an exemption. The V.M.I. Foundation would be one of those we call the public charity. It's supported by large individual donations over time. There are other provisions that relate to supporting organizations. And there is a governmental relationship with your supported charity. In this case, that would be like a V.M.I. And if we had administrative control over the trust, then we're out from under the requirements of the private foundation rules. Now, in that status that we have, we're stuck with the first with the Principal and Income Act. We've got this arbitrary distinction with respect to the allowance of principal. And we go through a series of legislative acts that I think are instructive Because your ultimate decision you'll be making in this case, you have only two options. You're going to decide whether the Wells Trust will be forever bound as a private foundation, and its annual distributions will be determined by Congress. Or you will rule in favor of the V.M.I. Foundation, and it is not a private foundation, and its annual determination of what the charitable benefits will be are determined by the General Assembly.
What about what the settler said and what he wanted?
In this case, the settler made it very clear. He provided an income-only trust. He entrusted the V.M.I. Foundation with the ability to properly use those funds while he preserved his trust in perpetuity.
Is that relevant to us, what his intention was?
I believe it's relevant because we're asking for the transfer of the assets on the same terms and conditions. A permanent fund, professionally managed, but freed from the expense burdens that are brought under the private foundation rules.
Right, and I understand that. That makes a lot of sense as a practical matter, but I guess I was focused on what Mr. Wells wanted and what he stated.
Well, when you're dealing with the question of a settler intent, first, is it solely for charitable purposes? There's no question on that. He wants an annual distribution of cash to be used as determined by the college endowment. The relief we seek will be the transfer of the funds to the V.M.I. Foundation, freed of the burdens of the private foundation rules, to be held as a permanent trust. And to help.
Could I jump in there before you move on, sir, to just follow up on the Chief's question? Under our precedents, the settler's intent is not only relevant, it's the poll star. And here we have a man who knew his way around trust, probably better than just about anybody in this room, certainly better than me. So his intent is particularly worth focusing on, I would think. I wonder if you think we ought to consider that in repeatedly settling these trusts the way he did, or at least in the final iteration the way he did, whether we ought to consider the possibility that he wanted his alma mater, the alma mater of George Marshall, and 3 generations of Pattons, or 2.5 generations of Pattons, right?
Yes, Your Honor.
To think about him and the class of 1924 each and every year, rather than dissolving this and sending it into the general treasury of V.M.I. on a one-time shot. That's my first question for you to answer. And my second one is, if you prevail, what is the principal distinction between your case and every other case, because every other private foundation is going to line up seeking the same relief as you are?
So with respect to his intent, we have subsequent events. And just as his will provides, the V.M.I. Foundation maintains 1,500 restricted funds. And his fund will be named in honor of his class, just as his estate document calls for it. And it will be among the 1,500 restricted funds that can do everything from funding scholarships to faculty chairs and so forth. So you do have that annual recognition, annual in the sense that we maintain the records of that generosity. So that's what he called for in his will, in honor of his class, and we're going to honor his class just as he provided. The distinguishing factor, I believe, between the two cases and the settler intent is the difference between his intent to use a vehicle of a trust, which we believe is, as the lower court did, we think that vitiates the statute. If you stop right there, what's the purpose of the trust termination statute? It recognizes there were changes in circumstances, the occurrence, whether it was it results from that separate existence, or result, will result. So it speaks in the future as well. And that causes these burdens to be incurred, the taxes. But the most important thing is it puts us in the position that the General Assembly now loses the control it normally has in defining this income versus principal distinction. And when you look at the series of statutory changes, you see that the General Assembly, in determining what that annual distribution would be, perhaps one of the most, once the dollars are in, the most important part of charitable management is how do I determine what that annual distribution will be?
Counsel, your argument is well stated and certainly plausible, except for the fact that the General Assembly gave to the Orphans Court the discretion to terminate if it finds that the fees and expenses are unreasonably out of proportion, and with the benefits of the charitable trust. Now, I find it hard. You don't suggest that PNC's fees are extraordinary in any sense. As a matter of fact, you think they're reasonable.
With respect to PNC's fees, in and of itself, the payment of, in quotes, reasonable trustee fees would not be a ground for the termination of trust. On that point alone, I would say it's an ancillary benefit if we make the transfer, which would go ultimately, if we're allowed to actually go through, bring Mr. Wells into the courtroom. But we can't ignore how the General Assembly has rejected the determination for how that charitable benefit should be determined as established by Congress. So when you go through the statutes, and we certainly start with principal and income.
I understand that, Counsel, and as I said, I follow your argument, except for the fact that the statute mandates a finding that the expenses and burdens are unreasonably out of proportion. Your argument seems to suggest that any fees and expenses incurred as a result of the manner in which this trust is set up are unreasonably out of proportion.
I would disagree, Your Honor.
Okay, so,
with all disrespect.
why is that not
because
what your argument
there's
is?
a quid pro quo there. There's a service that's being purchased. We have taxes, we have administrative expenses, and we have the most important part of this is the conflict between how Congress wants the charitable benefit to be determined, the methodology. And that's where the real crux of this case. The taxes are there forever. They're 1.39%. We acknowledge that you can conclude that they're not material. We respond, but they're in perpetuity, and they don't buy a single dollar benefit. They take assets out of the Wells Trust with no corresponding benefit, and they're not there to help the fund meet what the General Assembly has determined for how you are to determine those charitable benefits. In response to...
So let me just clarify. You're saying in this case, as a matter of law, these fees and expenses are unreasonably burdensome?
There's only one. Remember, they're not the only criteria for applying the statute.
It's the first criteria.
It's
the first criteria.
It's not the only one, though.
Well, how about as to the first one? Are you saying as a matter of law, under these circumstances, the fees and expenses are unreasonably burdensome. Because that's what I'm hearing. I mean, and I can't mesh that with the discretion that's placed in the orphans court to make that determination.
I would come back on the taxes. They're in perpetuity. They buy nothing for the charitable benefits.
Would that mean, counsel, if I could follow up, would that mean, because, you know, we, as you know, as well as I do, what we do in this case isn't just for this case, it affects, so that's, you know, the importance of this from our perspective is what this ruling would mean. So if I take your argument correctly, you're saying essentially that our Pennsylvania trust laws ought to be determined according to what Congress may on any given day promulgate in the Internal Revenue Code, or the IRS might promulgate by way of regulations, meaning that what our courts in Pennsylvania ought to do is be open on a continuing basis to accounting or mathematical arguments by beneficiaries on when the dollars and cents argue for dissolving a trust. I don't know where that process ends. Is there any kind of yardstick other than the bottom line of the tax calculation is going to result in a bigger amount if we just dissolve it and send it all to the beneficiary?
But you don't get there until you can make the transfer and eliminate the tax. That's the whole point of the trust termination statute. If you change that status, then these are the consequences.
Okay.
The consequences in this case, and I was certainly urged, is you have to look, the big picture here is determining what that annual charitable benefit is. And here, the General Assembly has been faced with this issue, and it resolved that in charitable cases, and in particular, that it adopts a different methodology looking at the total long-term management of a charitable fund. So we have the charitable instrument. Remember, we start with Principal and Income Act, easily understood. Income.
Well, I don't know if any of this is easily understood.
Well,
but counsel, can I just interrupt you for a second, because I think you're going back to repeating all these multitude of federal and state. I'm trying to boil this down to something that I can sort of understand. At the time Mr. Wells created this trust, the V.M.I. Foundation existed, correct?
Yes, sir.
Okay. So Mr. Wells could have just given the money to the V.M.I. Foundation.
It had an intervening life to take care of, which was his wife.
But
yes,
he could have.
He could have.
But he chose not to give V.M.I. Foundation control over the corpus, and instead wanted to have a private trust administer the corpus. Yes. That was the intent.
Yes.
What you seem to be arguing, and it's an interesting argument, is that his other intent was not only to have a trust administer the money and not the foundation, but to make sure that interest only was the benefit that went out of the trust, that the trust would retain the corpus, correct?
Correct.
Okay. And you're saying that there has been an intervening change in law since that was created and that intent was created that now prevents that intent from being satisfied.
Yes, sir.
And because that intent can no longer be satisfied, that triggers this provision to allow you to essentially terminate the trust, place everything in the hands of the foundation directly, to ensure that the intent of interest only can continue. Is that your argument?
What I think it misses is the General Assembly's response.
No, I don't want to. I want to go back to see. To me, the General Assembly's what the General Assembly did here was create an exception to the intent of the settler. This is a circumstance where the intent of the settler can be ignored, or not ignored, but satisfied, but not under the vehicle that the settler chose. So I'm trying to understand, you gave us this great historical tapestry of federal and state statutes. I'm trying to understand if it boils down to simply, because of an intervening change in the law, the intent to distribute only interest cannot be satisfied under the current vehicle, and therefore it's an out of proportion burdensome expense that Mr. Wells never would have wanted, and therefore the trust should be terminated.
In essence, it is, but I would come back. He operated under the Principal and Income Act. When the change in investment management occurred in the 1990s, the General Assembly responded, and it redefines income. And it does this in the context of the nationwide movement that arbitrary income-only test was not serving the charitable purposes of the industry. And it did so in this way. It adopts 1555-48 and subsequently 2081-13. And what does that do? It redefined income to a new formulation that's based upon a percentage of the asset base rather than this income only. Remember, in the last decade, when interest and dividends were only 2% or less a year, that was deemed an inappropriate way to maximize the charitable purposes of these gifts.
So the redefinition simulated what a reasonable income number would be if circumstances were better economically.
So if you look at the commentary to 8113, it makes it very clear that these amendments were to provide, in quotes, needed flexibility. And so the criteria that the General Assembly has come up with, it says the flexibility, and it's unlike other states. It says you will use a percentage within these bands, not less than 2 nor more than 7%. We're also going to mandate that you use an average of not less than 3 years of the asset values in determining what that annual distribution will be. And they allow you to change that as economic circumstances change, that investment returns can change, the needs of the charities can change. And that flexibility is denied solely because of its status as a private foundation. And so when they've adopted these acts, again, you had Mr. Wells said income only, defined by statute. The Congress said a fixed 5%, 1 year averaging. The General Assembly, in response, rejects what the Congress did and creates a new methodology for how income, meaning how that annual charitable distribution, is to be determined. And the public policy is the flexibility as returns change, and that they can change it over time. Eminently evidenced when you had the pandemic. And the General Assembly changed for 3 years and allowed charities to have a valuation of up to 10% a year. And so it changes that whole methodology so that if you brought Mr. Wells into the room today and you said he's an experienced banker, and a president of a bank and a trust company, he knew well how income was being calculated. He would be the perfect individual to be serving on your endowment board, your college board. And now we bring him forward and we say, here are the changes in circumstances of why the General Assembly changed from this well understood income only arrangement to this more flexible arrangement. He would then also understand why it imposed this obligation to average over a period of not less than 3 years to take out the peaks and valleys of how market values change over time. He also would have appreciated that the General Assembly, in adopting these two statutes, sets out a obligation to eliminate this distinction between income and principal in arriving at distribution, but also gives you a charge to preserve the real value of the fund.
If you're successful, counsel, I know I'm perhaps returning to something I raised earlier, but put it differently. If you're successful here, that the trial court abused its discretion, what possible defense would any trustee or the Attorney General have to any similar claim made by any other foundation acting as a public charity?
Well, first of all, it's only coming about because its status as a private foundation triggers these expenses and the denial of the application of how the General Assembly has determined the annual charitable benefit should be determined.
We have lots and lots of those foundations, including right here in Pittsburgh.
And
well, they have
that
to be.
Brings me to the question I asked you earlier. As a matter of law, you are saying, as a matter of law, in this circumstance, where this trust turns into a private foundation, a trial court abuses its discretion by not terminating the trust.
It has to meet two other requirements. One, can the transfer be made on conditions as nearly as possible to those set by the settlor? We're meeting there identical. It's just supporting unrestricted aid. Secondly, the beneficiary must be able to properly the beneficiary must be able to properly use and administer the fund. And so when you look at your prior case law about supporting charities, well understood in Pennsylvania, we've got a wonderful case, I suggest, that helps give some context about supporting charity.
Yeah, those two elements you're talking about aren't an issue in this case. Nobody's disputing those. The issue is what Justice Donahue said is the unreasonable in proportion. And again, maybe I just try to make things too simple. But you seem to be to finish with what Mr. Wells would do, because you were going down this list. Mr. Wells would appreciate this, and therefore Mr. Wells would want what?
He would want this transfer. First, he's starting now in the change of events. First, what the General Assembly has done.
Yeah. Okay. So that's my. So you're basically agreeing with me. Your argument is there's been a change in the law that there's been an intervening change in the law that Mr. Wells would not have chosen the trust as the vehicle today if given that opportunity, and therefore, because Mr. Wells would want to avoid all of the things that are either applying or hamstringing the private foundation, he would want to dissolve the trust and give it to V.M.I. Foundation.
I think that's exactly right. And the change in the status of the V.M.I. Foundation. At the time he was dying, it had $3.5 million in assets. 4 years ago, it had over $500 million in assets. It was one of the largest endowments per student of any public university in America. So Mr. Wells would have appreciated that.
Here's the problem, though. We can't conduct a seance and depose Mr. Wells, so we have to go by what he said and presume that he meant what he said. That's the problem I'm having.
But your whole statutory scheme in 40.9.3, you do this, and you've got it under the Cypre statute. You have it with a trust being too small. We have this very unique situation in which it is because of its status that creates these extra burdens, and the burdens in this case directly impact the ability of the trust, the charitable trust in this case, to achieve its objectives as the General Assembly has determined.
Are there benefits to some of those burdens, though? The trustee coordination and supervision by PNC, is there a burden to that?
Benefit.
I mean, is there a benefit to that?
Well, I would argue that the test for that is, as the Attorney General found, that there's no question that the V.M.I. Foundation can properly use and administer the funds. There is no question that these funds do not become a part of the general assets of the foundation. That's well established in the In re Craig estate, which makes it very clear. I can certainly read that if you would.
That's a great answer, but it doesn't answer my question. With respect to the current status, is there a benefit associated with the trustee?
No benefit that can't be replicated. But remember, the statute speaks to the very fact that you would continue, if you continue the precise terms, it says, other than the continuation of the trust. The governor on this is a finding that the V.M.I. Foundation, absolutely, it's not contested, can properly use and administer the fund. The draining of assets for no reciprocal benefit, we suggest, does in fact constitute an unreasonable burden.
Well, again, I don't mean to quarrel with you on this, but it's not that there's no reciprocal benefit. It's that there's a reciprocal benefit that you say could be replicated.
Well, again, I think I would refer us to your rules of statutory construction with some trepidation, because you know those far better than I do. When you begin to look at your various rules of statutory construction here, you do have to cross that hurdle about the intent is to benefit the public interest, not the private interest. And here, the private interest is what's keeping this case in play. And that is, what benefit is served by having this continued status as a private foundation? It's no answer to say, well, you got your 5% a year. What are you complaining about? Well, I'm complaining about the General Assembly has set up an entirely different paradigm. A different paradigm. It's irrelevant what has happened in the past, because you're not looking at it through the lens of what the General Assembly did.
But counsel, if your argument was as solid as you believe it to be, the statute would not give discretion to the Orphans Court to make a decision whether or not to terminate. I mean, your argument is essentially all of these three elements are met, therefore the trust must be terminated. But that's not how the statute is written. The statute is written to allow the Orphans Court to weigh its insights into the intent of the trustor. I mean, if this said the trust must be terminated if A, B, and C happens, you'd be on solid ground. But we have to look for an abuse of discretion here.
Well, and I think it still is a matter of law, because you still got the governor on this, which is you had to have the terms and conditions as close as possible to what the settler wrote.
But the settler wanted an independent third party to manage the investments. They can't have that with the foundation.
Well, that is the whole import of the trust termination statute. But you do continue a trust. You're still going to have an independent, and the discretion of the Orphans Court is applied when it looks to see, A, are your terms the same? They will be. Other than the why do you have the language in there other than the continuation of the trust? The next point is we had to be satisfied that this particular beneficiary can properly use and administer the fund, in which there's no debate about that.
There's no debate about that proposition, probably with respect to 98% of the beneficiaries that are going to parade in here after you win your case. I mean, by hypothesis, there are any number of similarly situated beneficiaries, which is why I continue asking you the same slippery slope question, and I don't perceive any real good answer to that, other than you would, I suppose, want individual Orphans Court judges around Pennsylvania idiosyncratically to make that call. I don't mean idiotly, I mean idiosyncratically, to make that call based on whatever strikes them as the equities or the math of a given case?
Well, you step back first. These statutes have been in effect since 1969. So people who are putting their trust in place would know full well when they're subjecting that charitable gift to the rules of the private foundation. So we don't have a flood of cases that are out there that have come to this conclusion. Your rules of statutory construction also cause us to look at other cases, for example, but also administrative rulings. And we have an administrative ruling in this case, and that was the Attorney General in Schlegel. It was asked, do you object to the termination of this trust?
Yeah, but that was a very different case. Schlegel was a very different, it wasn't our case, it was a Lancaster case, right? But it was a very different case, right? They were having all kinds of problems distributing the benefits in that case. They didn't know how to find the right kids, or they didn't have the right entities there to be on their committee or whatever. This is not that case.
Well, but Your Honor, but that what's different is that you still, just because they were having trouble, they should have been under the Cypre statute as an alternative. They took the case on the basis of the private foundation rules. Those taxes and other burdens were the basis upon which to terminate that trust. It had to then decide, was this new foundation, the community foundation, can they properly use and administer on the same terms and conditions as Mr. Schlegel provided? And so you have, and while that's not precedent, I'm not talking about the decision of the court, I'm talking about the administrative ruling that the Attorney General did not object in that case. And I think it's disingenuous when it argues now, well, but the trustee asked for it. Well, the trustee and the Attorney General were the only ones who could have brought the case under the trust termination statute, because there was an undefined group of charitable beneficiaries. So, yes, that was an administrative ruling that we suggest that you do take into account. And sometimes we have cross purposes here. And I would refer the court to the Moore Estate case, in which there was a statutory change in the inheritance tax law. Simple case. 1954, Mr. Moore dies. He leaves his estate in trust for the benefit of his wife. He gives her a power of appointment. 1956, the General Assembly amends the inheritance tax statute and provides an exemption for transfers of property to charity. In 1964, she dies, exercises the power of appointment in favor of charity. The court then is faced with the Attorney General, who's got those dual jobs, protecting charity on one side and the state's fisc on the other, argues that the exemption for charity does not apply because the power of appointment was granted prior to the adoption of the charitable exemption. The court rules against the Commonwealth and rules in favor of the charities. And I think this should be something to be considered in looking at all the aspects of this case. And it writes, because key here is charitable purpose driving the courts in this area. And it writes, this reading of the exemption statute, the court's ruling to adopt the exemption statute, comports with its obvious legislative purpose, as stated in Baum. At this stage of society's dedication to human welfare, we need not pause to recall the Commonwealth's strong, consistent, and very broad policy of assistance to charities and its long manifested encouragement to its citizens and businesses to make charitable contributions. It is difficult to conceive of a Commonwealth public policy that is more fundamental or more meaningful than its frequently restated policy of encouragement to charities and charitable giving in the public interest. Concluding, were we to accept the Commonwealth's view in this appeal, this fundamental public policy would be frustrated to a substantial degree.
I think that was an excellent conclusion. Do we have any other questions from the justices? Mr. Roberts, I'm glad that you came in from Virginia to give us that excellent argument, and I don't believe that you introduced your co-counsel.
My fault. Mr. Robert Weinberg, my co-counsel.
Yes, thank you both. Ms. Sager?
Good afternoon, Your Honors. I'm Margaret Sager of Heckscher, Tan, Terrell, and Sager, and I appear today on behalf of PNC Bank as trustee of the Perpetual Charitable Trust of Richard Wells. I'm appearing today with my co-counsel, Kristen Del Sol of the firm of Porter, Wright, Morris, and Arthur, and also here today with Tony Kowalczyk of the Office of Attorney General representing the Commonwealth. The Attorney General's Office and PNC Bank are united in this matter in seeking to oppose the termination of Mr. Wells' charitable trust, and we do seek affirmance of the decisions below. This court has asked us to advise the bench whether we will be dividing up the issues here. It's a little difficult in this particular case, although we'll try not to be duplicative. I will address the standard under Section 7740.3E of the Probate Estates and Fiduciaries Code, which is the PEF code, known as the PEF code, and it is Title 20 of the Pennsylvania Consolidated Statutes, as well as the application of Section 8113, also of the PEF code, that permits a total return investment approach and an adjusted distribution approach for all charitable trusts in Pennsylvania, including private foundations. Mr. Kowalczyk will address primarily issues pertaining to the Attorney General's role as parens patriae. It's important as an initial matter with respect to Mr. Wells' trust to recognize some important factors. This case does not involve allegations of mismanagement. It does not involve any allegations of malfeasance, abuse of discretion, or excessive fees. There has been no prior complaint by the beneficiary about the administration of the trust. There are also no material facts in dispute. Mr. Wells provided for distributions on an annual basis to the Virginia Military Institute Foundation, and that trust was actually funded when his wife died in 2004, and that's when the charitable trust arose. Previously, it was a trust for his wife. In fact, almost $640,000 has been distributed to V.M.I. Foundation for the period 2010 through 2020. During that same period, the trust has appreciated by approximately 40%, from about $1.5 million to $2.1 million. In short, and not to be flip, the trust of Mr. Wells works. The dispute before this court is caused by the fact, as we have heard, that V.M.I. Foundation is attempting to convince this court to rewrite 7740.3E and to completely disregard the mandates and prerequisites that are set forth clearly in that statute, and also to disregard Pennsylvania's legislative intent in enacting that statute. Furthermore, yes.
And I'm wondering if you have generated figures that would reflect the payout in the event that the total return statute wasn't passed in 1998, and what the payout would be without that statute, as well as if the transfer had been allowed so that the expenses that arise under the operation of the PEF code weren't impacted.
I do not have those figures. I can tell you, based on the record, that in 2017, 18, and 19, the average costs of the trustees' commissions and the federal excise tax that's charged against all private foundations in the country totaled on average about $12,500, and the distributions on average during that period to V.M.I. Was about $71,000. I don't have a comparison of the two, but the fact of the matter is that the statute.
Wouldn't those type of monetary figures be figures that could be argued by the V.M.I. Foundation to be the quote-unquote other burdens that make those burdens and the administrative expenses be unreasonably out of proportion to the charitable benefits, in that at the time that the founder of the trust created it, he didn't have any idea that these statutes were going to be passed and there would be that financial impact on his intent to gift this money to V.M.I. for the purposes of their foundation and their continuity.
Well, Your Honor, the fact of the matter is that the fund is appreciated, and so I think that's the most important aspect. And what you.
Yeah, it's appreciated, but I'm trying to tease out from you that it's appreciated this much. But what would have been the appreciation if this trust had been let to prosper and go forward without the impacts of those two the returns, the total return statute that was passed in 1998, as well as the operation of the PEPCO, which is strict.
So the fact of the matter is that this statute is in accord with Pennsylvania law in limiting the two specific circumstances where a charitable trust created by an individual can be terminated. And the statute says unambiguously that if the expenses and other burdens are unreasonably out of proportion to the charitable benefits, and that unreasonably out of proportion is a high standard. If they are unreasonably out of proportion to the charitable benefits, then the trust may be terminated. As Justice Donahue has noted, this is a permissive statute. It does not say the trust shall be terminated. At that point, if a court determines maybe even that the expenses and burdens are unreasonably out of proportion to the charitable benefits, the court could still choose to continue that trust for a variety of reasons. That is not our case.
What are those reasons?
So in the context of the statute 7740 pertaining to charitable trusts, there are not just the Cypre statute, which is about the failure of charitable purpose, which is not this case. There's also the provision allowing a small trust to be terminated, which is not about the failure of purpose or about the benefit, and that's where a trust is under $100,000. 7740.3E is like a bridge between those two statutes. And there's another provision about administrative deviation. So, for example, a court could conceivably, I could imagine a situation where a court says, well, the expenses and burdens are out of proportion, unreasonably out of proportion to the charitable benefits. We're not going to terminate the trust, but we're going to reduce those expenses, or we're going to change the trustee under 7766 or 7768.
We have to be, one, when the General Assembly grants discretion, it can't grant unfettered discretion. It has to provide guidelines, so there has to be statutory guidelines for the exercise of the discretion. And two, we have to be able to review it. Mm-hmm. So it can't just be if the expenses are out of proportion and the other conditions are met, the Orphans Court can say, I'm still not doing it. Well, that can't be it. There has to be some basis upon which the Orphans Court must articulate the exercise of discretion such that we can review it or the Superior Court can review it on appeal.
No doubt, and I agree with that, and that is not this case. This case.
Well, that's why I'm not sure why we went there.
You're talking about the discretion in the statute. So the discretion
But Justice
here.
Donahue's, or not Justice Donahue, Justice Mundy's question to you was, is there anything in the record or that you can point to that shows the difference, the delta, between the expenses and burdens as the trust exists today and the expenses and burdens that there would have been if it would be if we terminated the trust and gave it to the foundation in comparison to the charitable benefits. Is there something in the record, and I would suggest it would be the appellant's burden to put that in the record. Is there something in the record that shows us that delta?
There's nothing specific, but I have to say that the statute is about the expenses and the burdens unreasonably being out of proportion to the charitable benefits. And what are the charitable benefits? Well, the charitable benefits here force you to consider what Mr. Wells intended. So Mr. Wells said, I will give my estate, if my wife and my children all die, I'm going to give all of my money basically to V.M.I, which was what he did in 1956.
Well, he said, I'm going to give the interest.
No, he said he was going to give the assets outright to V.M.I in 1956. Okay. He then amended that trust 4 times, and in each of those 4 amendments, he instead decided, no, I'm not going to give that money outright to V.M.I. I'm going to put it into a perpetual charitable trust.
So could I ask you, could I follow up then? What looking at this statute, what is the test, if any, that you would propose we adopt in applying this, in guiding our trial courts? Because presumably it's not going to just be this beneficiary, whatever the outcome in this case, right? How are trial courts in Pennsylvania, in your view, to apply 7743E, unreasonably out of proportion?
It's a facts and circumstances statute that gives the court discretion to not terminate the trust, because Pennsylvania values our Pennsylvanians making charitable gifts and also honors and treats the intent of the donor as you mentioned, Your Honor, the poll star, and that is the most important thing. And this bench earlier this year in Garrison acknowledged the importance of settler intent. Mr. Wells, this was his money. He could do what he wanted with his money. He decided...
Well, actually, Brandeis wrote a whole book called Other People's Money and How Bankers Use It, so...
Well... Exactly, and he was a banker, and he was the...
That's why I said...
Yeah, exactly.
Your argument could apply to every private trust.
I don't agree with that. In the context of private foundations, if you had, for example, a private foundation, private charitable trust where the expenses exceeded the distributions to the charity, that would be a case where...
That goes to Justice Weck's question. So the test that you're adopting is that unreasonably out of proportion means the expenses exceed the distributions.
I am not saying that. I'm saying that would be an example.
Oh.
It's a facts
So
and
what's the
circumstances.
test?
It's a facts and circumstances case. Schlegel, which...
Well, we have to give some meaning to the General Assembly's intent.
Do you? Well, you do.
Right.
What you have to do is you have to read the statute and apply it, and not let V.M.I. Foundation rewrite the statute, because the V.M.I.
I agree with that. I guess I agree with you.
Yeah.
Excellent. I'm following Justice Weck's question, which you didn't really answer, which is, what is the test? Okay, so it's not that it has to be more expenses than distribution. So it's something short of that. What is it? Because there has to be something that cabins the discretion of the orphan court.
Your Honor, with all due respect, I think the orphans courts do pretty well in this category. And a lot of
there's a right to appeal under the Constitution. We have to have appellate review.
The orphans courts are very capable of applying a facts and circumstances case. And this statute, I mean, the Pennsylvania legislature could have enacted a statute that said if the expenses are equal to the charitable distributions, the trust terminates. It could have said any number of bright line rules like it did with the small charitable trust statute.
The challenge in your response, and I understand, I think I understand why you're giving Justice Bronson that response. The challenge on the other side of that is, suppose tomorrow, regardless of what happens in this case, suppose tomorrow that, consistent with your view, the orphans courts start exercising their discretion in a way that PNC and other trustees really wouldn't like, and start terminating these trusts willy-nilly. Since you're saying it's facts and circumstances discretion, do you recognize you're going to have a hard time overturning those on an abuse of discretion standard in the Superior Court?
Well, there hasn't exactly been a enormous onslaught of cases, right?
But there's no principled reason why that couldn't happen, right? I mean, in other words, there's like, if they get skillful advocates like appellant's counsel here in all these beneficiary cases, right, in the orphans courts around Pennsylvania, hypothetically, since you're not offering us any, and I'm not faulting you, I'm just teasing it out here, you're not giving us any real standard. You're just saying, let the orphans courts use their discretion. Okay, fine. So if that discretion starts going in a pro-beneficiary direction for whatever reason, then the answer according to your standard is, well, there go those trusts, right?
Your Honor, the fact of the matter is that the statute really forces a bench to look at settler intent. Contrary to the argument in V.M.I. Foundation's brief, we are certainly not saying that the existence of a charitable trust bars the application of 7740.3e. We're saying you have to apply the standard. The standard of that statute is the standard. Well, Your Honor, the Orphans Court, in its supplemental opinion and order, did specifically hold that, quote, unreasonable expenses out of proportion to the charitable benefit were not evidenced, and the Superior Court concluded that V.M.I. failed to meet its burden of the standard under 7740.3e. And I do want to talk for a minute about this issue of the 5%, okay? I could spend the next couple hours talking about the change in trust law across the nation.
Oh, please do.
Oh, I thought you'd enjoy that.
Please don't.
But I will refrain from doing so. But I'm happy to take questions on this. But suffice it to say that there is a more modern approach to the administration of trusts, charitable and non-charitable, so that it used to be income to A, remainder to B, and the definition of income has now been modernized so that the trusts in general are allowed to invest on a total return basis and make a distribution that is a percentage that approximates what the income would be if the trust had been invested on a more balanced basis, which, by the way, typically would result in less income. So the fact that this change has occurred not only on the federal side with respect to private foundations, because they wanted to make sure that money wasn't just piling up in private foundations, but money was being distributed to the charitable purposes ultimately. But the 5% is a red herring here. That is not the issue. And not just a red herring, but I have to say that Mr. Roberts mentioned a number of purported unanticipated circumstances, the 5% as an example. Putting aside that I can speculate probably pretty confidently that Mr. Wells, as the president of a bank and trust company, knew that this was in the works. He died in 1968. The Tax Reform Act is 1969. It had been talked about for a long time. It had been proposed several times. It just hadn't been enacted. So I would speculate that he knew. But speculating about that or not, the statute in this case does not include as a standard for termination unanticipated circumstances. What statute does? 7740.2, which pertains only to non-charitable trusts. And in that case, trustees can seek to have the court modify or terminate a trust. That language doesn't exist here. And if you're going to terminate this trust, which has excise taxes at 1.39% that are assessed against all private foundations, which are conceded by V.M.I. Foundation to be small, and you are going to look at the trustee fees here, which are based on PNC's schedule of compensation, which V.M.I. Foundation has conceded are reasonable, and under 7768, fees that arise under a competitive market are deemed to be reasonable unless there's compelling evidence to the contrary. There's no evidence of that here, and V.M.I. has conceded it. So when you start with this case and you say, well, the fees are reasonable, the taxes are small, but we're going to terminate it anyway because there's this 5%, then what you're going to end up doing...
Sorry to interrupt you, but and the investments of the funds have apparently been successful.
And the distributions have been substantial, and the appreciation in the fund has been significant. If you're going to terminate this particular trust under 7740.3E, then what you're going to have is what we refer to as a tsunami of public charities that are named beneficiaries of private foundations who will come marching in to terminate pretty much every private foundation. It will
under those facts, as you so eloquently laid them out, it would be an abuse of discretion for the Orphans Court to do so.
It would be. And it's absolutely clear that in this case, this whole conversation, if Mr. Wells were here today, what would he want? Well, we can speculate, but I can also say this is just not a pure numbers calculation process. There are many reasons that donors to charity decide that they want to create trusts, perpetual trusts, instead of making an outright gift. What do they include? Well, a lot of donors who, by the way, of course, let us all remember it's their money and they don't have to give it to charity. And we have a policy of encouraging that. And I think a finding to not to affirm here would have an incredible, not only the tsunami effect, but a chilling effect on possible donors.
Counsel, could I get back to the point that we discussed a while ago, which is the discretion of the trial court is driven by the facts and circumstances of the case. If we don't have evidence of this record that bills the date delta that Justice Robson was talking about, that should be the end of the discussion. What we know from this case is that there's a concession that PNC's fees are reasonable and the tax benefits or the tax detriments are small. Trial court looks at that and says, that's not an unreasonably out of proportion detriment as compared to the charitable benefits. Isn't that the end of the discussion?
It is the end of the discussion, and more than that, as I mentioned before, it's a permissive statute, and the court has discretion to not terminate the trust, which is what happened here. And the fact of the matter is going back to my point about what are the other benefits here for a man like Mr. Wells, because there might be an inclination to say, well, just give him the money, is that Mr. Wells might have said to himself, I want a fund that's just my fund with my name on it. I don't want to be one of a zillion donors to the endowment, whether it's segregated or not. He might have said, I want independent management of these assets, which makes sense because he was a banker. And he said, maybe he said to himself, I like independent management. I like the idea of having checks and balances where I have this trustee and I have the beneficiary and I have the AG. I like that.
And he liked banks.
And he loved banks, presumably. He was a man before his time in terms of rolling up banks. And
I'm not trying to disagree with you all day today, but I have to disagree with your statement because I think that you can have an administrative expense from PNC that's totally inappropriate, but it could be found to be not unreasonably out of proportion to the charitable benefit. And likewise, I can see a situation where you can have the PNC fees
Well,
that's my whole point to you today is that, and I just looked at the supplemental opinion, there's a boilerplate paragraph where the trial, the Orphans Court says, now it wasn't on the expenses and the burdens aren't unreasonably out of proportion, but I have no idea really what they balanced to come to that consideration. So I do think, to Justice Wecht and Justice Bronson's point is, like, where's the rule? Like, they have a mandatory appeal, but what are we supposed to do? You know, flip a coin?
well, I don't think it's.
If your answer is, well, let's full start with the intent, well, then let's look at the intent of Mr. Wells. Well, you know what he wanted. He wanted his money to go V.M.I.
Well, he wanted his money to be independently held and managed in a separate perpetual trust, a charitable trust, which cannot be totally disregarded. And the analysis doesn't work here, that this is not a trust with expenses and burdens that are unreasonable and on any level, and let alone unreasonably out of proportion to the charitable benefits. And the fact of the matter is that some of the aspects that V.M.I. Foundation points to as a burden, the 5% distribution, that's not a burden, that's a benefit.
Well, then the trial court or the Orphans Court should have discussed that. So we could look at what the reasoning was.
The Orphans Court came to a conclusion and exercised its discretion and decided that it was not going to terminate this particular trust. And I would say to Your Honors that this is not the trust to terminate, to use as an opportunity, so to speak, under 7740.3E to terminate a private foundation that's working, and a private foundation that is not by any stretch of the imagination having expenses and burdens that are unreasonably out of proportion to the charitable benefits.
Counsel, are there facts of record that support the Orphans Court's conclusion in this case that the administrative expenses and other burdens were not unreasonably out of proportion with the charitable benefits?
Well, as an initial matter, the parties all agree there are no material issues in dispute here, and the matter was determined based.
What are the facts that support the trial court's conclusion?
The court ruled on a motion for summary, on cross motions for summary judgment. So and you had a hearing, and that's how the court reached its decision. And again, the court has discretion.
Justice Donahue asked you
what is the evidence? What are the facts? What are the facts that support it? I've been reading about facts in the briefs and things of that nature. Nobody seems to want to talk about it. But, I mean, the tax benefits, for example, from the termination would be about $16,000 a year. Is that correct? If this, I mean, this is in the briefs. I mean,
No.
Is this in the record somewhere? Or, I'm asking you, what evidence in the record supports what the trial court did here?
I believe in the record. I have a good recollection of the motion for summary judgment. But the excise taxes are indicated, and they vary. So they are, on average, were about $3,100 over the course of 2017, 2018, and 2019. The distributions during that period were on average of about $71,000. And I believe that that's in the motion for summary judgment, cross motions.
Okay, so that supports the trial court's conclusion that $3,100 compared to the $70,000 supports the trial court's conclusion that the expenses were not unreasonably out of proportion to the benefits.
Correct, Your Honor.
Okay.
That would be an aspect of the analysis. Absolutely.
Are there others?
Again, the I would call intangible benefits that are to be taken into account that include the concept that the settlor chose to have his assets be held in a perpetual charitable trust. And I was going to go back to this point about what if Mr. Wells were here today, what would he say? I think Mr. Wells, because we're going to speculate, I would speculate that Mr. Wells would say, it's terrific that after 20 years that V.M.I. Foundation has benefited by more than $640,000. That was just for a 10-year period, so it's been double that. And that the assets of the fund have appreciated substantially. And it's still a separate fund that presumably he wanted. I think he would be happy with that. But we won't know. All we know is we can look at the document and we can see what he said. And he said, I'm going to have a perpetual charitable trust. And I don't think that at any level there should be a view that what's unreasonable are the standard and quite modest excise taxes and the fees that Mr. Wells, as a sophisticated banker who in his own trust said, pay the expenses out of the trust, and he was aware that there would be expenses associated with the separate maintenance of an independent private foundation. And the fact of the matter is if we're going to say that you have to have the lowest cost provider, because that's part of the argument here, is V.M.I. Foundation is trying to get this bench to rewrite the statute to say, if somebody else can manage this money for less, give it to them.
He was aware of those expenses. That's how he made all his money.
That's exactly correct. He was a sophisticated settlor here. He's not your average guy, and you have this trail, this extraordinary trail of his original gift and in the trust in 1956, where he does leave the money outright to V.M.I., and then he changes his mind. I mean, some people want to protect their own charitable funds, even, for example, from the claims of creditors of the charity. Schools and charities go out of business. They get sued. You know, there are any number of reasons he would have wanted to have that separate independent fund. And he knew there were expenses. And he directed that those expenses in his trust, he directed that those expenses get paid from the trust. He directed that the trustee here be paid based on their schedule of compensation, which, by the way, I assume his own bank had a schedule of compensation, and he was very aware of that as well. And we have to give settlors the ability to give their assets to charity using the vehicle they choose. For us to sit here years later and say, hey, the charity which can do it for less, and by the way, charities always want their money outright, right? They always do. And they will always say that they can do it for less. And maybe they can do it for less. But there are these other intangible benefits that presumably Mr. Wells was interested in and that he knew all about. And that was the thing he chose to do.
Well, and maybe tangible benefits too, such as the degree of appreciation.
Right. What, exactly, Your Honor. You have, I mean, this is not a case where the assets are diminishing. This is not a case where they get a little bit of money every year. This is a situation where PNC has masterfully managed this money with a 5% distribution and a 40% growth in a 10-year span.
Well, it was his money. It was his money. He settled the trust.
It was his money.
I mean, come back to the settlement.
It was, at the end of the day, it was his money. I do a lot of estate planning, and I tell my clients all the time that it's their money, and if they want to put it in the driveway and set it on fire, they can. I don't recommend it. Very few clients go that route. But I do have clients who say, I don't want that charity to get the money outright.
Well, if they're going to do that, they should pay your fee first.
That's for sure.
They should
of course,
put a
that
little
goes without saying, Your Honor.
Stack over there. My question is, when are you beginning that 2-hour history?
Well, you can hardly wait, I'm sure.
All right, I think we understand your argument, Ms. Sager. Let's hear from the Attorney General's office.
I thank you for your time today, and do ask that you affirm the courts below. Thank you.
Mr. Kovacic? How'd I do with that pronunciation?
It's Kowalczyk, but that's okay. That's close. Thank you, Madam Chief Justice.
I thought I hit a home run there.
My name's Anthony Kowalczyk. I'm a Deputy Attorney General for the Commonwealth of Pennsylvania, and I'm here on behalf of the Commonwealth. In order to avoid repetition, I'm going to try to follow up on Justice Weck's question and address any other questions that may come up. In terms of the standard for interpreting Section 7740.3E, I tried to provide guidance in the brief, and it actually relates very closely to what I was preparing to say anyway, and that is, if you look back at the history of your jurisprudence, okay, what the V.M.I. Foundation is essentially doing is trying to displace over a century of precedent. I'm aware of, the earliest one that I'm specifically aware of is the UNRWA's estate case, which this court decided in 1915 when it refused to terminate a trust that had been set up for an orphanage, at the request of the orphanage. The standard for interpreting it, I'm not going to try to put numbers on it, but the 1924 decision that you issued, Bachman's estate, specifically says that termination of a trust, in that case it was a church, is not appropriate if the settlor designates that mechanism for giving his or her gift, unless termination is necessary to facilitate or give effect to the trust, the settlor's expressed purpose. And that standard, I think, is actually very similar in many ways to what the Court of Appeal of Illinois said in the Church of the Little Flower case, which I also cite in the brief, which is the only case that I could specifically find where an appellate court addressed a request to terminate a trust at the behest of a beneficiary, specifically because the trust was classified as a private foundation. And the Court of Appeal of Illinois, that was 2012, said it's inappropriate to simply terminate a trust because the beneficiaries would be a little bit better off or get a little bit more money than they would if the private foundation were to continue.
Okay, so I see a little difference, and maybe I misheard you, between your first articulation of the test and your second articulation of the test. The most recent articulation being it would unreasonably out of proportion does not mean there would be less administrative expenses or administrative burdens than there currently are.
Yeah, because the unreasonable has meaning. But
right.
Yeah, go ahead.
But you were first said something along the lines of if the intent of the settler somehow wouldn't be fulfilled. And certainly if that were just the test, as long as there's a $1 distribution and ridiculously high administrative expenses, the intent of the settler is being satisfied because there's a distribution of $1. So it has to be, I liked your last articulation over your first one, which is look at the charitable benefits in toto and compare it to the burdens of this current thing, and are they unreasonably out of proportion? Is the administrative burden, you know, and again, I think the trial court, the Orphans Court, to Justice Donahue's point, has a lot of discretion here to determine what is reasonable and unreasonable under the circumstances. But is it so high that that the General Assembly's decision that we may displace the settler's chosen vehicle is triggered?
The standard is the standard that so high that it has to literally offset the dollar.
Well, I don't know, but it can't be your first articulation, which is basically as long as the settler's intent of a distribution of income is you can't end it. There has to be something else.
Well, where I was going with that was actually the Court of Appeal of Illinois went on to say that in order for the trust to be for termination to be appropriate, the trust must be so inefficient that it interferes with the trust purpose. And what I was doing was drawing a parallel between what they said in that particular instance to what you said in 1924, and saying even though we have a different standard, and even though they don't have the same statutory language, the test appears, what they're saying is what they were calling an appropriate way to look at it is the exact test that this court applied in 1924.
Were those tests interpreting the General Assembly's use of the phrase unreasonably out of proportion?
They were not, but the General...
We have to give intent to the General Assembly, not the Supreme Court of Illinois or Iowa.
I agree with that, but what I'm alluding to is the fact that the General Assembly is presumed to be aware of the legal principles that exist when it legislates, and it doesn't necessarily
in the Appellate Court of Illinois.
No. The principles that this court articulated. Okay,
right, which means that their intent could be to either codify it or override it.
Yeah, and I think in this particular instance, it's closer to codify, because this court has consistently held for over a century, dating back to 1915 with Umra's estate, and the case I was alluding to, Bachman's estate, 1924, that a beneficiary can't just come in and terminate a trust without showing that the intent of the settler, the charitable intent, can't be fulfilled unless the trust is terminated. And
again, I'm going to push back on that standard, because the charitable intent could be fulfilled even in the presence of high administrative fees. So are you saying that is the standard?
The standard is, if the charitable intent were defeated by
What does that mean, defeated?
Essentially overcome to the point where the fees are grossly out of proportion with the charitable benefits. Which
So unreasonable means grossly.
Well, and yeah, it has to have some meaning. It can't simply be a burden. So I guess if you take, that's actually a good analogy, because the term reasonable care usually applies in negligence cases. Gross negligence would be a level up. So that's actually a good analogy, Justice Probson, because gross negligence is something that normally exceeds negligence. It's not an ordinary reasonable care. It's a more egregious breach. Unreasonable burden would appear to require some kind of heightened showing of that kind. Yeah, I think that's accurate. I think that's actually the analogy I'm trying to draw.
Their burden was under the statute. Tell me why I'm wrong. Under the statute, they had to prove with evidence that the burdens, regulatory, financial, otherwise, were unreasonably out of proportion to the charitable benefit, which could include multiple things, not just the actual financial distribution. It could include multiple things. And they just failed to meet their burden.
Well, I think that's definitely correct. And I also think...
So do we need to put a percentage on what unreasonably out of proportion means, or is that something within the discretion of the trial court in an individual circumstance?
I think it is within the discretion of the trial court. I don't think you need to put a number on it. But I also think that when you go to the issue of discretion, and this is important, okay, we're dealing with a statute that uses may and shall in it multiple times, like this court said in Zimmerman versus O'Bannon. When the legislature uses may and shall in the same statute, may clearly means may, shall means shall. So there is an element of discretion, okay? But that discretion is not unfettered. Of course it's not. But in this particular case, the trial court, in exercising its discretion, specifically looked to what Mr. Wells, not only what he intended, but what he did. Okay, because his original iteration of this trust in 1956 included a possible outright gift to V.M.I., and that was 1956. That was 20 years. I believe the V.M.I. Foundation was in existence in 1936, if I remember correctly. Okay, his initial iteration of the trust did include an outright gift. Then the next three iterations of it didn't entitle V.M.I. to anything. It simply created a trust and then gave the trustees discretion to give to the charities they saw fit, but to give favorable consideration to V.M.I., and then brought back into play a trust where V.M.I. became the sole beneficiary in 2004 after Mrs. Wells passed away. Okay, but in any event, the trial court's discretion was not completely unfettered. The trial court looked to what Mr. Wells actually did. And in
I understand that. I guess that's true of every private. This goes back to Justice Weck's point earlier, which is every private, every beneficiary could make that argument. I'm wondering. Let's change the facts a little bit here. Let's simply say, they proved to the trial court, our administrative fees and burdens under the federal tax laws and state laws and everything like that are 40% of the annual kick-out distribution to the beneficiary. That's too high. And the trial court said, we agree, that's too high. 40% is way too high. Would that be an abuse of discretion for the trial orphans court to dissolve the trust at that point in time because a 40% in relation proportion to the benefit is unreasonable?
I think it depends on the size of the trust, Justice Robson. And I think you have to look to the statute for evidence of that, because the General Assembly actually did provide a bright line rule in Section 7740.3D, subsection D. Okay, and if the trust is worth $100,000 or less, it actually can be terminated because it's presumed that the benefits would be,
Well, this trust doesn't
meet that. So I think what I'm trying to say is, I think the answer to your question about 40% may very well depend on the size of the trust. At some point,
but it could be assailable on appeal.
Yeah, depending on the size of the trust, how much money, how much the charity is benefiting from the continuation of the trust. Clearly, they haven't satisfied the standard of showing an unreasonable burden in this case, because the trust grew from $1.5 million in 2010 to $2.1 million in 2020. Substantial distributions made. I believe it was $639,000 over that 10-year period. So I don't think we're anywhere close to that here, but I think there may very well be cases where your 40% example would constitute an unreasonable burden, but I think it may very well depend on the size of the trust, because the smaller the trust is, the less the charitable benefits might be. At some point, the administrative burdens may very well outweigh the charitable benefits.
So you're of the view then that this is a question of the facts and circumstances as presented?
Absolutely.
So the 40% fee, if what had to happen in order to identify the beneficiaries of the trustee had to go door to door in neighborhoods in order to locate the appropriate individuals, and they had to hire dozens of people in order to accomplish that, that might be necessary to administer that trust. I mean, it depends on the facts and circumstances.
That's true, and actually I'm glad you brought that up, because the Schlegel case from Lancaster County was a situation where the recipients, the charitable beneficiaries, were not readily identifiable, and they had to create a panel of advisors to go and look and figure out who we're going to give the money to. And that's what made the administration of that trust more difficult, and that's one of the reasons why the Attorney General did not object, why we didn't object in that particular instance. We don't have that problem here because PNC Bank has been administering the trust. The trust has been growing, and they've been sending money to the V.M.I. Foundation, and and there's no reason to terminate this trust. It's going exactly as Mr. Wells intended.
All right, Mr. Kowalczyk, do you have anything else you'd like to tell us before you sit down?
I don't. If you have questions, I'm free to address them, but I don't have anything specific.
No, I think we
I
understand.
used all my questions up on Attorney Sanger.
Yes, unless Attorney Del Sol wants to add anything.
Yes.
All right.
I just asked that you affirm the Superior Court's decision.
Gotcha. Thank you. It was almost a CLE in trust law today, so we should be awarding some credits. Thank you.
Thank you.
Call the next case.
Nice job.
Right. Correct. That's correct.
In this case, the property of the parties, the Galapos and the Oberholzers, share a common border. After Mrs. Oberholzer made an allegedly racist remark to Mr. Galapo, the Galapos began posting anti-racist yard signs facing the Oberholzers' property. Eventually, the Oberholzers sought a permanent injunction prohibiting the Galapos from posting these signs. The trial court granted relief in part, ordering the Galapos to position the signs so that the text on the signs could not be seen by the Oberholzers. The Galapos appealed to the Superior Court, arguing that the injunction constituted an unconstitutional prior restraint on free speech. The Superior Court rejected their argument on the basis that the injunction pertained only to existing, not future signs. The court also held that the injunction was content neutral, as it was unrelated to the messages on the signs. However, the court vacated the injunction and remanded the matter for further consideration by the trial court on the basis that the trial court failed to apply the proper standard of review in determining whether the injunction was constitutional, specifically whether the injunction burdens no more speech than necessary to serve a significant government interest. In this appeal by the Galapos, we consider the propriety of each of the lower court's determinations.
Thank you.
Good afternoon. May it please the court. My name is Amy Kirkpatrick, and I, along with my co-counsel Andrew Kramer, represent the appellants in this matter, Simon and Toby Galapo. We are here today in the first instance to ask this court to not only affirm the holding in Willing versus Mazzicone that equity will not enjoin defamation in this Commonwealth, but that the Willing opinion should be read to extend to all tortious speech. The Superior Court never reached whether Willing applies in this case because, as the Chief Justice mentioned, the court decided that prior restraint does not apply to pre-existing or ongoing communication. If we look at the case law cited throughout our brief, and some of it cited within the Superior Court's brief, it's clear that no case law has ever held that. That has never been the definition of prior restraint anywhere in our Commonwealth or in the federal courts. The Superior Court started their decision by noting the Philadelphia Newspapers versus Jerome case and used that case as an example of a definition of prior restraint, citing the quote that a prior restraint prevents publication of information or material in the possession of the press. We don't see that applied that way in our cases.
Counsel, the judge's injunction here, it did not prevent your clients from expressing any particular opinion or idea in the future, correct? That would be the definition of a prior restraint in the context of this case, wouldn't it?
I would disagree with that characterization. My clients want to express the ideas on their signs specifically to the Oberholzers. That is their intended audience because they want to change the behavior they feel that the Oberholzers are exhibiting towards them. So in turning around those signs, the court's restricting my client's ability to reach its intended audience.
Well, let's be clear. These weren't defamatory signs or defamatory messages.
That is our position.
But
there
there's
has been
an argument on that.
There's really not an argument on that. Our position has always been that Willing versus Mazzicone applies whether these signs are defamatory or not. Plaintiff's complaint actually includes 5 separate counts: defamation, false light, nuisance, intentional infliction of emotional distress, and invasion of seclusion upon privacy. The 5th and final claim was actually dismissed on motion for summary judgment. There was never a finding in the court if any of those counts applied, because we settled the tort claims so that we could focus on the injunctive relief, which was really both parties' issue.
And this injunction is premised more, it's fair to say, on a nuisance theory than on any kind of a defamation theory. I mean, the context upon which the injunction is premised here is the home.
Well,
isn't that the basis for the ruling by the trial judge?
I can't say that one way or another because I don't think the trial court tells us that.
But
However,
it sounds like nuisance.
And one could say that. I guess that would be the visual aspect of it would make it a nuisance claim, but the words of the signs could make it defamation or false light. I don't see any way it's an invasion of privacy. The trial court did not either. It dismissed that claim. There's an argument that it could be, it's intentionally inflicting the emotional distress.
I'd say the words on the sign, I mean, the judge said it's content neutral, so that in theory, the words on the signs are not addressed. Well, no, in fact, the words on the signs are not addressed in the judge's order. It just says turn them around and make them opaque. So on that line of thinking, Applts tell us, and the Superior Court tells us it's content neutral. Do you disagree with that?
Well, I think first we're mixing up questions here, right? The first question is.
I'm good at that.
Yeah, no. The first, it's a complicated area of law. I think we can all agree that the First Amendment law is tough. But our first instance here today is that Willing versus Mazzicone applies. It's a prior restraint. Prior restraints are presumptively invalid. Set that aside, you then get to the content-based, content neutral. I would strongly disagree with you that this is not, or with the court, the Superior Court and the trial court, that this is a content neutral injunction. When you look at content neutral, content based, you also have to look at the intent of the injunction and what it's supposed to be remedying, why it's put in place. And in this case, If we go back to Franklin Chalfont, it's a very similar case. The issue in Franklin Chalfont was that the builder did not like the wording on the sign and the light it placed it in and what it did to it. Same thing here. And in that case, we said, of course it's content-based, because the only reason this injunction was put in place was because the complaining party didn't like the words. That's exactly what we have here.
But your words were, but the sign. See, what's difficult about this is this is essentially a dispute that I'm still struggling with why it is even here, why these two grown-up parties can't resolve this in a grown-up way. But my problem is I know you said that the privacy claim was put aside, but how can you ignore the fact that this picketing, which is essentially what it is, it's a private picket directed toward the home, why the trial court couldn't balance the interest in the constitutionally protected interest in the tranquility of the home as recognized in Frisbee by the United States Supreme Court, why that doesn't just prevent this. This isn't somebody holding a picket out in front of a business. This is directed speech that impairs or affects the tranquility of somebody's home. At least that's what the trial court found.
Sure.
So I mean, help me understand why that's wrong.
Absolutely.
If we allowed everybody to do what your clients want to do here, we'd have posting of signs all over the place in residential areas against neighbors just because they don't like them or don't care for them and condoning bad behavior.
Maybe. That said, going back to your question, to the beginning of it, so first and foremost, when we talk about when we're talking about privacy and weighing that interest, we're talking about a time, place, and manner restriction. Time, place, and manner restrictions really arise under the public fora doctrine. This is not any sort of public property. This is private property. If we look at the
on both sides.
On both sides, exactly.
Exactly.
But the posting location is the important location when we're talking about the signs and how we're applying the First Amendment.
What if it's not signs? What if it's a sound system directing sound toward the other property?
You're getting to the end of my answer to your first question. So if it were sound, it would be a little different. Then we could look at the Klebanoff case. Then we could look at SmithKline-Beacham, and we could say that is absolutely invading the privacy of the home because you're inside your home, right? And it's laid out in Klebanoff. It's laid off in SmithKline. They can't leave their driveway without being accosted by people on their sidewalk.
Here, they could pull down a blind or put something up on their porch that they don't
build a fence, plant arborvitaes. Don't look into my client's private property. They don't have to do that. I'm sorry?
Could they build a fence?
Absolutely.
There's no zoning ordinance that would prevent.
Not that I'm aware of.
Is the burden on them? Because I saw that in the ACLU's brief, which is a very good brief. The ACLU ended its brief by saying if it still bothers them, they could put up a line of trees or build a fence. Is the burden on them to abate the nuisance?
I would argue yes.
Or is the burden on your client?
There's United States Supreme case law where they talk about the unwilling listener and that there is a level of responsibility to avert the eyes. That's why we allow things like leafletting and things of that nature.
Those are in public spaces.
I'm sorry?
Those are in public spaces, though.
For example, mail billing. Putting things in mailboxes.
Right, but that's somebody accessing a public right-of-way to put something in somebody's mailbox.
My client's only accessing their own property. They're not accessing the Oberholzer's property. The signs aren't on the Oberholzer's property. The Oberholzers have to look into my client's yard to appreciate the signs.
Okay, so let's say the Oberholzers build a fence. Let's say the local zoning ordinances or the local homeowners association allows maximum 5-foot fence, but it has to be it can't be solid. It has to be a fence that you can look through. That doesn't help them. Let's say it allows a solid fence, and your clients decide, well, it's a solid fence of 5 foot, so we're going to erect a pole and put a giant billboard or a sign that's higher than the fence. Where does this end?
Well, I think there's two sides to that, right? The first side is they're not limited to a fence. They can plant a tree that grows 50 feet in the air. All right, that's something they can do. On my client's side, that's where you get into ordinances and things like that where the courts say, you can have a 6-foot fence, but you can't have something taller than 6 feet. And so that's where that side comes in. So it's not this sort of free-for-all where my clients are going to put them on the roof and things like that. It's definitely...
What? You say that. but that's supposition. But my understanding was that your clients indicated that they're keeping these numerous signs until they believe that the Oberholzers admit or apologize for their statements.
Not admit or apologize. The intent is to have them change their behavior. And I know it's not spelled out in our brief because that's not the focus of the brief. I would direct the court, if the court's interested, to the hearing transcript regarding the preliminary injunctive relief from October of 2016, where my client outlines all of the behavior that they are subjected to from the Oberholzer and why they erect the signs.
Well, but if their intention is to cure what they perceive as racism, 100 signs advocating, fairness and treating people well and anti-racism messages aren't really designed to do that. But my question is, with respect to the lower court ruling, do you think it would have been any different if the signs had just had happy messages, don't worry, be happy, have a nice day, and had nothing to do with anti-racism messages?
Yeah, and we can look at the record and see that, because there were other signs that were posted that were not of the ilk described. So, for example, there was a no trespassing sign. There was a sign warning that there was audio and visual surveillance being undertaken. There was a hate...
But they all had to be turned around.
No, those signs did not. Those signs are not part of the settlement agreement.
What about hate has no home here?
That was the third one. Sorry, I was about to get to that one. That one is not turned around either. That one is not required to be. It is only the signs that plaintiffs have specifically identified to the court that they are unhappy with, that my client is restricted from posting in the manner they wish.
What about the signs pertaining to the Holocaust, never again? That's a sign that has to be turned around?
Pursuant to the trial court's order, it has to not only be turned around, it has to be altered in a way so that the Oberholzers cannot read the messages backwards. That is how far the trial court has gone to ensure that the messages my client wishes to communicate and make available to the Oberholzers cannot be made available.
That's kind of... I think your client admitted this. The reason why they're posting the signs is to annoy the Oberholzers.
Never said that. They never said it was.
What did he say?
They did not want to annoy the Oberholzers. They want to
educate.
Not even educate. I would love to say that it's educate. I would love to say educate.
I don't think they said educate.
They didn't say educate. No, my client made clear that the point of the signs is that the signs go up and down based on the Oberholzers' behavior. Again, that's outlined in the injunctive relief, the initial hearing transcript from October 2016. I can
just imagine imagine the power of that if we say trial courts can't stop that. I mean, the amount of signs that will proliferate between neighbors who can't get along. I mean, the easiest thing for them to do was just not to talk to each other. Or move. Well, I don't know if move is easy, but wow, what an adult thing it would have been to just not have interacted this way.
Your Honor, I appreciate that, and I agree. You're absolutely correct. However, that's not what my clients chose to do.
But if we say that trial courts cannot address nuisances of conduct of this kinds of signs that are not just random acts of, I want to support Black Lives Matter or I want to support end racism. This was a result of targeted angst toward a neighbor. And regardless of how innocuous the signs seem in the abstract, in the fact, it was intended to be targeted toward a neighbor with which there is a dispute. And if we allow that, society just breaks down. The personal tranquility of the home breaks down. They can't leave. I understand they couldn't go outside, but that's just like saying, well, if your neighbor puts up a sign you don't like, I guess you're never going to enjoy your yard. Oh, you got to spend a couple $1,000s to erect trees or a fence. And really, is that where First Amendment law is in the United States?
I would direct this court to Organization for Better Austin versus Keefe, United States Supreme Court, and also Franklin Chalfant, which is a Superior Court Pennsylvania case, where the courts talk about the fact the coercive nature of the signs, that doesn't make it unprotected speech. That doesn't mean that you're not allowed to do it. People might not like it. For example, in Keefe...
Are those cases involving rear yard of person versus rear yard of person?
Front yarded.
Yeah, front yard, out to the public, out to the street.
I'll give the factual basis for both of them. So Keefe was a leafletting case where it was a realtor whose practices an organization was trying to changed through leafletting and putting the information out to the general public to basically, let's say, embarrass that party into changing their behavior. And the United States Supreme Court said that doesn't make it lose its protected quality, even if it is meant to be coercive. And then when we look at Franklin Chalfant's, the idea of it was these yard signs where it was homeowners who had bought from a builders across the street in their, their little trailer or whatever, and they put these signs up and they said, we're not happy with our home, et cetera, and it was meant to coerce them into accomplishing what needed to be done on their punch list by making it so that when potential homeowners came in and they saw the signs.
You don't see a difference between outward-facing signs into a street, viewable by the public in a public right-of-way, as opposed to signs in a backyard not facing the public, but facing someone else's backyard, someone else's home, which the United States Constitution, which the United States Supreme Court has said is deserving of special protection.
I do see what you're pointing out. I do see the difference. That said, if the Oberholzers were across the street and they put the signs on their front lawn,
it might be a different case.
But how is it different in terms of the effect it's having on the Oberholzers?
It's not the effect it has on the Oberholzers. That's an exercise of speech out to the public. This is targeted speech at individuals. It's not about expressing, to me, it's less about expressing a First Amendment right and more about getting back at the neighbor.
Well, in the scenario you're outlining, if the Oberholzers lived across the street and we put the signs on our front lawn because that's where they're at, it would
public expression of speech to the public.
But it's still targeted at the Oberholzers.
I understand.
The intent's still the same.
That might be a somewhat different case, at least. Can I follow up on this this home issue that Justice Brobson was asking you about? You had mentioned Klebanoff. Klebanoff, there, the court enjoined or upheld an injunction against picketing the physician's home by the anti-abortion activists, and that was not premised solely on noise, as I recall. It was premised also on the presence of the picket signs outside the home. So if that kind of an injunction was upheld, how can you maintain that equity lacks the power to enjoin this kind of conduct?
I would disagree that Klebanoff doesn't focuses on the signs. It actually speaks specifically to the fact that the injunction in that case was content neutral because of the fact that the messaging on the signs had nothing to do with the injunction. It would have just as much applied to any other of the activities being conducted because that case was an expressive conduct case, where the expressive conduct was what was causing this invasion of the residential privacy because you have bullhorns, you have people that are blocking the driveway, they're accosting the neighbors, they're scaring children, doing really, we can all agree, terrible things because they don't like that Dr. Klebanoff performs abortions. And that was a totally different case for many reasons, but one of them is the content neutral versus content based. There's also, that's a time, place, and manner restriction because it was a public sidewalk, not a private property, even though it's adjacent to a private property. And then also, it was under the time, place, and manner analysis, you have to have alternative channels of communication. That's, again, something we do not have here. In those cases, they said, Klebanoff, Smith, Klein, Pennsylvania, privacy interest cases, the courts always said, you can go to the commercial area where these people perform these objectionable things, and you can protest there. In fact, in Smith-Klein, when the second injunction was entered and said you cannot protest at all at the business location, the court said that's not an acceptable injunction because that's not leaving open and available channel. In this case, my clients or the Oberholzers, their conduct is part of their personal life. We're not objecting to them what they do in their business life. It's what they're doing in their personal life. My clients have no other way to reach them than except at their home where they are committing the things that my client is opposing.
Counsel, are we to presume here that there was a finding that your client committed some tort? What's the basis that we're working from here?
And that's a tough one in this case because there is no base.
Well, but see, that's the problem with deciding this case in the abstract because, you're asking us not only to say that defamation cannot be enjoined, but no tort, tortious conduct can be enjoined. What tort?
And that's exactly, well, in this case specifically, the 5 outlined in the complaint.
Yeah, but What's the predicate for the preliminary injunction that was entered in this case? Somebody had to decide that there was a reasonable likelihood that somebody was going to prevail on the merits of something. What was that?
There was no preliminary injunction entered. It was actually only the permanent injunction that was entered.
Okay. And what was the basis for the permanent injunction?
It was never stated by the trial court.
Well, then how do we decide this? I mean, because I could say to you, I agree with you. You can't enjoin defamation, but that doesn't mean that your client can't be responsible for a monetary damage. For example, plant trees, we say to the neighbor, and the neighbor says, fine, you committed a tort, you pay for the trees. See, we aren't in a situation here where we could get our arms around what precisely we're dealing with here.
Well, I think
even a declaration that it was a nuisance, was there?
No.
There was a settlement.
There was a settlement.
An undisclosed monetary amount.
Exactly.
What does that mean?
So the settlement
You didn't settle the preliminary injunction because you want us to grapple with that, but I'm asking you, grapple with what?
So essentially,
but what? What's the tort?
Sure.
What do we? You want us to expand the law or apply the law, and I'm saying I don't know how we could possibly do that unless somebody has decided that your client committed a tort. And then you tell us what the tort is, and then we could look at our law and say, can we enjoin this defamation? Yes or no? Can we enjoin a nuisance? Yes or no? What if we do? Does that mean your client pays the neighbors for the planting of the 12-foot tall arborvitae? But see, that's what I just can't, I can't get my arms around what you want us to do here and on what basis, or on what basis we should do it.
Sure.
All of these arguments about the case law, and there are many, and some are close and some are not, but see, the problem is in all of those other cases, there were findings as to liable conduct. We don't have that here. I don't even know if the trial court thinks your client actually did anything tortious.
That's a good question. We don't know that. That is true. If anything, that errs on the side of not having an injunction. But I would submit to the court, our argument as all along has been, it doesn't matter what the underlying tort is, because willing should be read not to be limited to defamation. Willing actually addressed defamation and libel, because the injunction in that case spoke to, it literally said defamation/libel.
It's the same thing.
Exactly, yeah.
Libel is a species, libel and slander.
Sure.
But this willing didn't even rely on that. It called it the so-called traditional view that equity lacks the power to enjoin the publication of a defamatory matter. And I read those Volok and Chemerinsky articles that the ACLU cited, and they disagree on the defamation thing, but we don't need to get into it because that's not what was being enjoined here. It was those other species of alleged tortious activity.
Or was
it? The nuisance type theories. That's what the court was enjoining, not on the defamation prong. Can you respond to that?
So, and I think I'm understanding, but tell me if I'm wrong once I give you my answer, but our position is that all of these torts, as alleged, are all based on the speech itself, right? It's the words on the posters that are the issue that the plaintiffs have always claimed are what give rise to their claim. They say that's speech, whether it is we're calling it a nuisance, whether we're calling it intentional infliction of emotional distress, whatever we're calling it is tortious. And our argument is that we shouldn't be limiting willing to just saying, well, we don't enjoin defamation. It should be we don't enjoin tortious speech, because the consideration in willing was, is there a way to recover for these damages, right? That's the whole thing about an injunction. If you can't be satisfied with something, right, then there should be an injunction, because that's the only way.
You're elevating the speech over the nuisance. And
no, the speech is the nuisance in this
I understand,
case.
but the courts issue injunctions to abate nuisances, even nuisances that involve speech.
But those would be considered content neutral, because it's not the speech that's the issue, it's the attendant circumstances, which is probably noise in most scenarios. So if you're out there with a bullhorn saying all the things on these signs, and the court said no, you can't do that, that's a nuisance, it would be because of the speech, or I'm sorry, not the speech, but the actual verbalness of it and the noise of it. It wouldn't be the words itself that's the issue. In this case, it is literally the words that are the issue. It's the words that are giving rise.
I would suggest it's not even the words, it's the signs.
Well, we know it's not.
Counsel, I have a question. I've read this opinion over and over, and I agree with Justice Donahue that there's really no factual determination or finding here. So the question I have for you is it your position this is about the government involvement with the Oberholzers' right to have enjoyment of their own property, or you believe this is government involvement trying to prohibit, limit, restrict your clients' expressing of an opinion?
It's the latter.
So if it's the latter, and you're permitted to still have these signs just pointed not facing your neighbors, what's the issue?
Again, we spoke about this really early on. They are the only audience that those signs are intended to get to. The intended audience is just as important part of speech as the speech itself. I could talk about this case until I am blue in the face to my husband, but who cares? You six are the ones that can do anything about it.
But signs are facing its intended audience, and signs are not. So
not anymore. Under the injunction, they're no longer facing the Oberholzers, so the Oberholzers can no longer appreciate the messages on the signs.
Would you agree that we, in this case, must balance your clients' expressive rights under the First Amendment, in whatever measure they are afforded or protected, against the right to privacy and quiet enjoyment of the home? Do you agree that there's a balancing that needs to be done here?
Only if you determine that the injunction itself is content neutral. That's when you get into that analysis of whether there is a significant interest. In this case, it's content-based. We would argue that if it's content-based, obviously, it's got to be a compelling government interest. It has to be narrowly tailored. We would argue that in this case, when you're talking about that residential privacy, you also have to look at the actual effect it has on the privacy. So I wouldn't say it's a balancing between the two. I would say it's almost a balancing between Klivenoff and the facts here, because in that case, the court said that was a significant government interest because of all the activity going on. I don't believe that it would be a compelling government interest in a scenario where the only way that the Oberholzers can appreciate the signs is by looking into my client's backyard.
That's what I was going to ask. Isn't there part of the equation where you balance the rights of the property owner to do what they want on their property? It's not like it's smoke that's blowing over onto their property. It's not like it's noise that's being blasted over the property line. In order for the neighbors to be offended by the signs, they have to look in your client's backyard.
You are exactly right. And that's something that hasn't come up yet, is that my client has their own privacy interest and the interest in using their property as they see fit. I mean, we could take this the opposite direction from what Justice Brobson was saying, and we could say, for example, say my clients post, a LGBTQ flag, pride flag, and the plaintiffs don't like it. They say, that's I'm Christian, and I don't like that, and I find that offensive.
It could be totem poles. It could be modern art. It could be
whatever.
Trees with decorations on them for a holiday they don't subscribe to. The list is endless.
Yeah, they've asked the court, because they don't like something on my client's private property, they've gone to the court and asked the court to take the full force of the government and come onto my client's property and tell them what they can do. And this is not an ordinance where you have, I don't want to say lesser, but there's, the considerations are much different, because an ordinance applies to township-wide.
I suppose if you're right, then the Oberholzers could put signs in their backyard targeted toward your clients that say all kinds of things that your clients would dislike.
Yeah, I was just going to ask you that. So you would have it would be fair for your clients to say, Jesus saves, put Bible quotes, say,
sure.
People who...
Yeah, absolutely. They can absolutely do that. They have that right. And that's the thing about the First Amendment, is it protects speech that we don't like.
I'm going to look at these cases again. I'm struggling where your argument goes as a society, and whether the framers really intended this kind of thing, because they did place paramount interests of tranquility of the home, and the United States Supreme Court has recognized it repeatedly. And you're basically saying is, nope, we can engage in sign wars, and it really doesn't matter what the signs say, right? Your point is the signs could have completely benign things to normal human beings, but if they're going to get under the skin of the neighbor, we have every right to put them up facing the neighbor, and the neighbor we can just engage in a sign war.
Mm-hmm. Yeah, what I would say is this. I understand where you're coming from. It's not a likable fact pattern. I get that.
I can't believe it's here.
I understand your position. I get that. But what I will say is, number one, I don't think we see it on a greater scale. I don't think the societal impact that you're talking about, I don't think we're going to see it become...
We're going down some interesting societal impacts
Sure.
that I haven't seen in a long time. And this is getting scary.
Up till
Tolliver should have appointed a mediator and just ended it.
I'll take him out for a cup of coffee.
Well, I will say this. The Abington Township Police Department was unsuccessful way back when, so...
It's very interesting. Can I follow up on something you just said? Or Justice Brobson was asking you, and you, I think you agreed when he was asking you, it didn't matter what the sign said, or I think you just said that it wouldn't matter what, or you indicated yes when he was suggesting that you're talking about a situation where it didn't matter what the sign said. Is that right? Because
as long as it annoyed the neighbor, it doesn't matter what they say.
Yeah, because I thought earlier you were saying you challenged whether this was a content neutral injunction.
Well,
my colleagues couldn't be convinced that the injunction in SS versus SB was content specific. So I don't know how you're going to convince people this one is content neutral. But anyway, is it content neutral or is it not content neutral in this case?
It is not content neutral. I was answering in terms of like the broader, not just specifically to this case. So I might have misunderstood what he was asking in that scenario. But no, in this injunction, it is a content-based injunction. The only basis for this injunction is that the Oberholzers do not like what those messages are.
Okay, so then let me ask you. Okay, so following up on what my colleagues are asking, since this whole thing began, and I don't know why we're speaking in euphemisms about racism. This was an anti-Jewish slur made by Mrs. Oberholzer. That's what this is about. And I don't know why everybody's being euphemistic about that. But in this case, what if the Oberholzers responded consistent with what Mrs. Oberholzer said with a bunch of Nazi swastikas? Would you say that was protected speech? And it didn't matter that it bothered the Galapos' privacy in their home? Because to be consistent with your argument, I think you'd have to say, yeah, they could put up their swastikas, and it's too bad if it bothered the Galapos in their privacy.
In this country, as unfortunate as it is that you can do that, you can. Now, there's a whole other line of we could go into with ordinances and what happened. These are all kind of, we're looking at fact patterns and kind of extrapolating them and all that. But yeah, in that instance, unfortunately, I think they could. Could my clients then sue them? And and then we go from there. But I think when we look at the case law as it is, our Commonwealth is very protective of speech.
But it's also very protective, as my colleague Justice Brobson was saying, of people's right of enjoyment of their home, both under the U.S. Constitution and under our own. It doesn't seem like you want to take that side of the ledger into account at all.
No, it's not that we don't want to take it into account, but free speech rights are in our federal and state constitution. The right to privacy is not within our federal and state constitution.
It's in our state constitution.
Okay.
And it's recognized by the United States Supreme Court.
It's extrapolated from the Fourth Amendment, sure.
Penumbras and emanations.
It's a penumbra.
Our speech amendment is number one. When we look at the history...
That just means it was drafted first.
Sure, because that's the first one that came to mind, right? No, but when we look at the history, and I think the ACLU's brief goes into it a little bit more, but it talks about, and some of the cases, in the Pennsylvania cases actually talk about the fact that, our free speech constitutional provision goes all the way back to William Penn, and it goes back to what William Penn experienced, and we have kept that as a primary tenet of our Constitution because of that history. And, that's what the First Amendment is. That's what our, Article 1, Section 7, it's protecting the speech we don't like. And, that's what it really comes down to. And I mean, we talked about.
I think there's a difference between protecting speech in the public square that we don't like versus protecting speech that is intentionally targeted toward individuals in their rear yard, because that runs headlong into a separate constitutional right.
Sure. I think what that says, though, is that you have less speech rights on your own private property than you have in a public forum.
Well, it just means, like Justice Oliver Wendell Holmes Jr. said a long time ago, my right to swing my fist ends where your nose begins. That's the principle. So that, anyway.
So how would you like us to decide this? And I'm getting back to, my earlier question. Do you want us to say that your client had an absolute right to post these signs or any signs on their property, regardless of the content that was directed to the neighbor, and therefore there was no tort, therefore there was no action to be enjoined? Or do you want us to do something else?
So I want to just put something out there before I answer that question real quick. You said that I believe that my clients could speak freely without any consequence. That is not the position we're taking. Our position is that under our Constitution, we are allowed to speak freely, and we have to be responsible for the abuse of that liberty. By settling the tort claims, we were responsible for the abuse of that liberty. Our settlement agreement provides damages for past, present, and future posting of the signs.
That's helpful to me, because that gets back to my point.
Yeah, because
you're saying there was a tort. We have paid in monetary damages. Under the Pennsylvania Constitution, you don't enjoin speech.
Absolutely.
Period.
Tortious speech.
He said settle all the claims.
Yes, he did.
We settled all the tort claims.
Yes, he did.
Including the nuisance?
Yes. We settled all the claims. If you go back to the release says that we do not admit liability on those claims. It goes on to say, however, we're going to take the position that we have a First Amendment right under Willing, regardless of what tort it is, because it all arises from tortious speech. And so that's why we're getting rid of those claims, and we're leaving only that issue before the court.
And your position is that the language in Amendment 1, Section 7 of our Constitution, being responsible for the abuse of that liberty, applies only to law and not to equity. And what I'm saying is I don't see that. I understand that the offhand citation in Willing, but after reading the Chemerinsky and Volok, I don't see that if there's conduct that has been adjudicated unlawful, even defamation, there's no principled reason why the court must allow that conduct to continue once it's been why? Because it's lost its constitutional protection. Because defamatory speech is not protected speech, right?
Under the federal Constitution.
If we can agree on that,
Under the federal
then that's okay, call it federal. Then if we can agree on that, then by hypothesis, other torts, nuisance, false light, etc., intentional infliction are going to be even more susceptible to injunction. Would you agree?
No. No, I would not agree with that, because under Willing, the Supreme Court in Willing went back through Goldman Theaters to our Section 7 and said, in this Commonwealth, we are going to adopt and uphold and maintain the traditional view that equity will not enjoin defamation. We do not follow the federal rule on that. We don't, other states might, we don't. So what we're asking today is, and if you are saying that Pennsylvania does not allow defamation, right, that it's not protected speech anymore, you've overruled Willing. So what we're asking you to do is to not overrule Willing, to keep Willing in place as it's been for the past 45 years, as the federal courts and our lower courts have been relying on it, and clarify that it doesn't matter how you cast your claim. Because we see that if we look at some of the federal...
You've blown my mind, though. Why? It sounds to me like you've set us up to decide something that isn't even an issue anymore. Because because everybody just wants to know we're going to do this. Are you telling me that you settled everything?
We settled all the tort claims, and we left.
What claim is left?
There are no tort claims that remain unsettled.
What's left?
The injunction.
The injunction of what?
The post.
A permanent injunction is a form of relief. It's not a claim. What claim didn't you settle?
None.
They're all settled.
All 5 claims are subject to the settlement release.
The Oberholzers agreed to take a sum in monetary damages to allow you to continue to have the signs up.
Yeah. Well, no, I shouldn't say that. They accepted a settlement amount.
You said future damages.
Yes, they accepted a settlement amount to compensate for past, present, and future damages.
You can only have future damages if you have the signs up.
And we reserved that future damage in the event that the injunction was denied, and we could then keep posting our signs.
Are your signs up now, the Galapo signs?
The last I confirmed with my clients, they are up, but facing backwards. They face my client's property now. So my clients, the messages are on my client's side.
What do you mean you reserved it? I don't understand. What did you reserve?
So when we settled those 5 claims, what we said was the only thing that's outstanding is there injunctive relief available? And their argument was yes, our argument was no, based on Willing and Section 7. And so we said, we're going to let the trial court decide that, because that was really the only issue between these parties.
As relief for the torts.
Exactly. And our argument was there is no relief for the torts because of Willing versus Mazzicone.
But the torts that you settled, where you reserved you conceded that the trial court could feasibly, although you would disagree that they should, could conceivably grant injunctive relief in addition to the settlement damages.
Yes.
Okay. So that's what so it left open an additional remedy relative to the torts.
Yes. And our position was that remedy was not one that was available.
So that is still active. And is a remedy.
The issue of the settlement, the reason the party settled was nobody wanted to go to trial on those issues. Nobody wanted to be bringing in their witnesses and going through all that, when the real issue that all the parties cared about, all either side cares about, is whether the signs can be posted. The money and all that was a side venture for everyone. So that's why those claims were settled, and that's also why we reserved that right to future damages, because in the event that the court said, I'm not going to grant you injunctive relief, we wouldn't have a new complaint the next day when we didn't take our signs down.
The point being is all those claims that you settled,
yes,
we can look at for purposes of determining whether injunctive relief can be granted.
Our position is you can look at any one of
them or all of them.
Any one or all of them, and apply Willing versus Mazzicone, because every single one of those torts arose from the allegation that my clients engaged in tortious speech.
And your client is accepting the consequence of engaging in this speech by paying monetary damages.
Absolutely, they already
have.
That's what
you helped me with earlier. Okay?
Absolutely.
So we have that as the predicate. So the only issue is when a defendant has paid monetary damages, can they also be enjoined for alleged tortious speech?
Exactly. Our position is that Willing held no, because we say in cases where there is a monetary award available, we're not going to do that under our state constitution.
Can I follow up? You mentioned Willing repeatedly, and I don't think Willing so held. I think it mentioned but didn't rely on that so-called rule. But in any event, you go on, you're arguing not just that equity cannot join defamation, but injunctions in all tort. You want to talk about tort generally, and
tortious speech.
Yeah, I want to, right, tortious, yeah. Is there any state that's gone there? I'm not aware of any state that's extended that idea to that extent.
I can't say that we researched that issue.
Well, wouldn't that be a huge shift in our jurisprudence? I mean, because injunctions that impose narrowly tailored time, place, and manner restrictions in all the picketing and protesting cases, presumably they'd all be unconstitutional under your argument.
No, they would not, because they're expressive conduct, and this is a pure speech case.
You're saying what the Galapos did is more pure speech than people picketing and protesting?
Absolutely. My clients
Even though
don't.
they're in a backyard and next to their neighbor.
My clients don't attend to the signs. They're not standing there with them. They don't have a bullhorn yelling anything. That's expressive conduct, right? When we look at those abortion clinic cases and things like that, the speech, the anti-abortion speech, has nothing to do with the injunctions. It's because of the way they act. And we say those actions are the problem here. And we say, you can do your speech, but you got to be, for example, 36 feet away. That's not what we have here.
If you leave today and there's a rally going on Grant Street, people having signs and a rally for whatever, you're saying that's expressive conduct allowed less constitutional protection than the Galapos putting up signs facing their neighbors, and that's pure speech in their case. That's what you're saying?
Pure speech is less restricted than expressive conduct. There's, off the top of my head, I can't tell you what case it is, but there's a quote that says, as you move away from pure speech, the right to regulate becomes stronger as you get to expressive conduct.
Counsel, you indicated that your client is pure speech and not expressive conduct. Is that what you just said?
Much more closer to that end, yes, absolutely.
All right. On notes of testimony, 103, page 103, 9 to 13, 21 to 23. The question was by Mr. Woodside regarding what was the sign's purpose, and your client indicated, quote unquote, the idea behind the sign is my protest against racism. That's it. How is that not expressive conduct, and how is that pure speech out of the words of your client?
Sure. First and foremost, my client is a doctor, not a lawyer. So he's not.
Counsel, with all due respect, you're the lawyer.
Sure.
You gave us an argument that it was not expressive conduct. I'm asking you a very simple question.
Sure.
The question's very simple and centered. How is the fact that your client said the idea behind the signs is my protest against racism? That's it. Nothing to do with the Oberholzers. Share with me how that's how is that differentiated from other expressive conduct?
So expressive conduct, as it's outlined in the Madsen case, Klebanoff, Smith-Kline, et cetera, the court goes very heavily into the facts and talks about what the people are doing when they're trying to get their message across to the people they are opposing. And the things they are doing, for example, in one case, they are graffitiing vehicles. They are blocking driveways. They are going up to the neighbors and questioning the neighbors and doing all these physical things, right, that we can point to as actions. My client used the word protest. When he uses protest, he doesn't mean walking down the street with a sign protest.
We don't know that. You can't argue that because it's not before this court. All that's before this court is your client's admission that he was protesting racism, not that he thought his neighbors were bigoted anti-Semites.
Well, protesting is also another word for objecting, and that's what he was doing. Yeah, exactly. He
has signs. That is a form of silent protest.
Yeah, he's objecting. When he says protesting,
I can only go with what the record says. I can't suppose what other than the comments of the party.
What we can do is look at the conduct that he's engaged in versus the conduct in the other cases, and we can know that if we're calling Klebanoff and Madsen and Smith-Kline and all those cases, if we're calling that conduct protesting, then what my client is doing is not protesting.
Well, and there are no facts in this case to indicate there's anything other than signs at issue.
There's nothing else other than signs at issue.
See, I think this case is incredibly different than all the cases that you're citing, because in those cases, you couldn't just drop a sign and leave. They had complete control over the property that they were posting the signs on. It was their property, and they had complete control to direct it over to the other property. They didn't have to sit there. They didn't have to hold the sign in their yard to make their point. They could put it down. All the cases you're citing about are picket signs where people literally had to carry the sign because they couldn't stick it in somebody else's property and leave without it being taken down.
Well, the Franklin Chalfant case, that was the situation. In Franklin Chalfant, they posted signs on their own front lawn, and they also posted in the windows.
But again, that's a different case. That doesn't involve the peaceful tranquility of somebody's rear yard. Again, here's my only point. Here's my only point. This case, to me, is monumental. You can't cite a single case that you have cited from the U.S. Supreme Court or this court or a Pennsylvania court or another court for that matter that deals with this rear yard, person-to-person neighbor dispute of the facts that you present here. And that's why it's significant that if we recognize what you're essentially saying, I just don't know if the framers intended that. I really don't.
Well, I agree with you that we don't have anything factually similar anywhere.
So we do. We have the whole corpus of nuisance law. I mean, they don't usually come to us, but there's nuisance cases litigated in magisterial district judges' courtrooms every day. Quite a lot of fun. And common pleas courts. And so, I mean, and a lot of the circumstances are ludicrous, but at the bottom of them all is still a constitutional principle of privacy in the home. So I think there is that sort of set of legal principles over here that, again, you seem to be just totally ignoring.
Well, I can't speak to the cases that you're talking about because I don't know specifically what you're talking about with those nuisance cases, but I would bet they probably involve noise and not just the posting of words, because that would be a different consideration. And I would have to guess that the court in that scenario, if you just had signs, would say, where's the nuisance? Because there's no noise coming into the home. In this case, you could argue, right, nuisance, you could argue visual blight, but we know that's not a case here because the physical signs are still here. So if it's a visual blight nuisance, that's not an issue here because that's not addressed by the injunction. So we know it's not a visual blight issue, and we know it's not a noise issue. So I can't think of any other action that falls under a nuisance claim. So I would suggest that in this scenario, where you're just talking about words, you wouldn't find that scenario.
Okay, I think we understand your argument.
One question. The settlement. It encompassed a payment of damages and acceptance of responsibility for defamation.
We did not admit liability for the claim.
I didn't say that. I said accepted responsibility.
You could.
I used your language. I'm
sure. You could say that money was exchanged
and
in recognition of those torts,
including defamation.
Absolutely.
Okay, thank you, Mr. Patrick. Let's hear from Mr. Woodside.
Madam Chief Justice and the justices here today, I'm Stephen Woodside of Ballackinwood, Pennsylvania, and I represent the Aplts, Denise Oberholzer and Frederick Oberholzer, better known as Rick Oberholzer. In our jurisprudence in Pennsylvania, signs seem to be a particularly thorny problem. There's an awful lot of case law, it's very robust, about signs and signage and how it arises and what it might constitute in terms of where it's directed or targeted and whether it can be restrained or not. Here's what we know in this case, and I want to develop the analytical framework of the case before I move into some of the things that Appellant's counsel tried to argue to the court. First, we have a stipulated record in the case. When the case was in front of Judge Tolliver, we had already had a preliminary injunction hearing in front of, I think, somebody else in Montgomery County, Bernard Moore. And so not only did we have in the stipulated record the testimony that I was able to obtain from Dr. Galapo on cross-examination, but we also have testimony of two eyewitnesses who saw the backyards, a Geraldine Smith and a Christopher Tinsley. This is in the record. We have the Oberholzers' testimony in their depositions, and we have literally hundreds, I think, pictures of the backyard and the signage and where it's placed. The argument here is, under the analytical framework, in these kinds of cases, I always want to know, when there is speech involved, I always want to know at the earliest moment what is intended by the speech. The speaker, what are you intending to do? Are you intending to make a statement to society through normal formats of either publication or some kind of other means electronically, or are you using the speech more like an expressive method to protest something or to object to something or to complain about something along those lines? And so we have my client only, not Rick Oberholzer, made a racist comment.
Why are you speaking euphemisms? It was an anti-Jewish comment.
It was.
Why is everybody being euphemistic and saying racism? It's an anti-Jewish comment made to a Jewish couple. Why can't we call it what it was?
It's a racist comment, and
Why
it's in the record.
They made an anti-Jewish comment.
It's anti-Jewish. It would have to be, and Rick Oberholzer in his testimony admitted it.
Euphemism all over the case.
But he admitted it in his testimony. And so when I had the opportunity with Dr. Galapo in the injunction hearing, I asked the doctor about what he was doing with the signs. And so Justice Dougherty did mention it, but it's a little more detailed than that because, first of all, one of the justices asked appellant's counsel about this, and it is in the record. What Dr. Galapo wanted to do was stop the behavior of racism as we perceive it, and then the signs will come down. So he's using the signs to try to change behavior or conduct. That can be restrained when the receiver of the speech, the Oberholzers, is severely disturbed or bothered by it. All the case law discusses the speech from the content of the unwanted recipient, not the person making the speech. So when
that's also in the context of a home.
Yes, in the context of a home.
There's a difference. You can't stop somebody. If you're walking down the street and there's a protest, you can't go and get an injunction and say, I'm offended.
Justice Robson, you're absolutely right. And in speech, the law assumes a willing listener. But when you get to the case where you have an unwilling listener or someone who feels invaded by the speech, especially in their private home, this is where the law has the power under our own jurisprudence to step in and make a correction.
I think that's fair enough. But what about opposing counsel's argument that this was merely a sign? It wasn't talking. There was no picketing. There was no loudspeaker. It's just a sign so you could presumably avert your eyes, build a hedge, build a fence, put up a tree, not look over there, etc. What do you say to that?
Well, what I say to that is I would defer entirely to Judge Tolliver's order on the injunctive relief. And it goes to the question of, let's set aside the nuisance question and the standing question for just a second. And let me talk about Judge Tolliver's order. Judge Tolliver, in his order, there were two of them, one on post-trial motions and one in the lower court, following the stipulated record being submitted on briefs and oral argument. Judge Tolliver did not mention anything about any content or word or language or anything on the signs. He simply stated that the signs, the fronts of the signs, shall not face the Oberholzer's property and shall not target the Oberholzer's private property, and the signs as previously posted, which is the ones that are enumerated in a settlement agreement, shall remain. And so when the signs as previously posted shall and can remain, he was dealing with placement. The placement of the signs was along the very backyard of Dr. Galapo's property, right against the creek line, which is no less than 10 feet away from the beginning of my client's backyard property. So if everybody, justices, if you want to discuss, let me draw the blinds, let me plant a tree, the concern I have with that is that the signs are so close to that creek line in terms of where they are. They're a little bit up on the hill, like maybe 10 feet to get a vantage point, but when you're in the Oberholzer's backyard or in their home, you got the Florida room, the first floor, the second floor of the house, the dog area that's penned off, and the whole backyard of the Oberholzer's house abuts these signs. They cannot be avoided by any means. And so let me go back to what I wanted to find out from Dr. Galapo when he was on the stand in this court hearing. Here's what he says. I said, if I was going to pick one sign that you wanted to post to describe what you believe the Oberholzers are and put it along the boundary line, which is where they were, just one, go through my evidence notebook and show me which one you would pick. Dr. Galapo says none. So obviously he's not picking a sign. He had a chance to do it under oath. He didn't pick a sign to explain anything about my clients. He didn't pick a sign in my notebook, which are all his signs, to explain anything about what he believed about my clients and what they were. He simply said, again, I said, pick one sign that you would want to post to describe the Oberholzers. Dr. Galapo says, I told you that's not the purpose of the signs. So already, I know in this case, at the injunctive hearing, when, by the way, all signs were down on their consent order, but I still held the hearing because I wanted to know what was going on with them. And so that's not the purpose of the signs. And then Dr. Galapo testifies, the purpose of the signs is to protest the behavior of what the Oberholzers have been doing in a racist fashion to me and my family. So now I know he's got signs that he doesn't care about in terms of what the lettering or the content or the symbols are, because he said the signs don't matter. I'll get to that in a minute. And then he says the purpose is to protest a behavior. So now I got a defendant using the First Amendment that he's trying to hide behind to protest something about my clients, and that the signs, he wouldn't pick a single sign to describe them. And then I asked the doctor, let me ask you this. You haven't been able to identify a single sign that you would want to put up there, and now you said that you're not going to put up any sign, right? Dr. Galapo says the sign is not the issue. The issue is getting somebody to stop the behavior we perceive as being racist. And then Dr. Galapo testified, these signs, it could be any sign, it doesn't matter. So I walked out of the injunction hearing thinking he has no sign that is indicative of what he believes my clients are. He's only using the signs to protest my clients in a behavior that he didn't even explain, and now he says the signs are not an issue. So what is the purpose of Dr. Galapo's speech? The purpose is he's at the far end of the spectrum. We have, one of the cases discussed the spectrum of First Amendment speech, a bunch of other things happening. Judge Tolliver, in his opinion, wrote that it's not, he was very careful when he wrote this. He says it's not a pure expressive protest case, and he said it's not a pure speech case. And then when he said that, he said nothing more about the signs. Judge Tolliver didn't identify anything on the signs, not a word, a letter, a symbol, and he only talked about the placement of the signs, and he referenced, in his opinion, he referenced Dr. Galapo's position about what he was intending to use the signs for and why, and then Judge Tolliver very correctly in the lower court, he wrote two opinions, but in the larger opinion adjudicating the case, he wrote that the privacy interest, it's Kerry v. Brown, a U.S. Supreme Court case, it's that privacy interest that one has in their private residence that is just inveterate. You cannot, first you can't force speech on an unwilling listener, and of course the Oberholzers are not willing listeners. And then if the speech is impacting, and the judge wrote in his opinion, severely impacting the Oberholzers by what he saw on the record, the two fact witnesses, the Oberholzers' testimony, the signs themselves, and he saw where they were. Judge Tolliver only wrote about the placement of these signs and the fact that it was the placement of the signs together with the fulsome record developed in that lower court.
Can I ask a question on that?
Yes.
I mean, I think that's a good summary, but it's not only the placement of the signs, it's also their orientation. So you're right about the unwilling listener, but there's another doctrine in the First Amendment law that the message has to be one that the speaker can convey to the intended audience. Are you maintaining that doctrine or principle does not apply here because of the domestic setting?
Yeah, well, let me try to answer it as best I can. All of the cases that talk about that in terms of the intended audience arise in the context where either defamation, libel, slander, or something else is being enjoined. And therefore, the courts usually find that there is a generally accepted means of disseminating the speech, whether it's a newspaper article or I got something going on where I want the general society to know about an important public societal interest. And so again, to stay with the facts of this case, I don't see where Dr. Galapo identified any societal interest whatsoever that included anybody outside of targeting the Oberholzer's home. And that's...
May I?
Yes.
Are you familiar with the case of City of Ladue versus Jaleo? Which is
sure, I am very familiar. You want me to talk about it?
Yeah, because that in essence permits, the language is, A person who puts up a sign at her residence often intends to reach neighbors, an audience that could not be reached nearly as well by any other
Let me talk about the City of Ladue case, and I didn't hear appellant's counsel talk about it, but it is a case that does deal with a residence and a residential homeowner posting a sign in the window of her home, and it said, "Peace in the Gulf." However, there's something called the captive audience doctrine, which was a case after the City of Ladue, which is Sorrell v. something, is a 2011 case, Supreme Court case. And that is where this captive audience doctrine really developed, and our jurisprudence already covers it. However, in Ladue, we dealt with, first of all, an ordinance, not an injunction. And secondly, the court determined that the ordinance suppressed one complete method of speech that the homeowner had to put the sign in that was not directed to any other homeowner. The homeowner simply wanted to put a sign in her window. I don't know what window it was. The sign was 8.5 by 11, and there was an ordinance that said, unless you're accepted or you fit one of the exceptions of my ordinance, which discriminated both against commercial entities like churches and then against people like the lady in Ladue, you can't put the sign in the window. So the court struck down the ordinance on the basis that it discriminated against one complete means of expression because the lady wasn't putting her sign in the window to harass a neighbor or invade a neighbor's privacy. The lady put the sign in the window because she wanted to convey a message, I guess, to whoever drove by the home. So
we can distinguish the facts, but the principle of law is that an individual is permitted to put a protest sign on their property for purposes of sharing that message with neighbors, which is exactly the scenario that we have here today. So how, outside of the fact, how do you distinguish the principle of law from the application to this?
All right, here's what I can say. And that's a really very, very fair question, Justice. The lady in City of Ladue had one 8.5 by 11 sign in her window, and the allegation was you're violating an ordinance, and the ordinance is overly broad and underly broad, and therefore the ordinance is stricken down, and you can keep your sign. In this case, we're dealing with over a 4-year period. 24 hours a day, 7 days a week, 365 days a year, give or take the period that there was a consent order that took the signs down. We're dealing with 21 signs that are abutted right up against my client's property that they cannot avoid. Nobody in the City of Ladue complained that the sign was offensive to them, or it was, you were targeting my home with that sign, or you intended to use the sign to protest something about where I put a trash can, or what I'm doing here, I got somebody serving in the military. So the analytical framework of Ladue doesn't match at all the controlling law in this case. Although I recognize the fact that the case holds for the fact that you're a private residential landowner and you ought to be able to post a sign on your yard. And the ordinance shouldn't tell you that you can't do it if you don't meet the exception. That's not this case. The appellants are complaining here, again, that I've heard, this is like about the 4th time, that because they feel that my clients were complaining about the symbols and the letters and the things that were on this sign. Therefore, it's got to be not content neutral. And the case law and the jurisprudence in our Pennsylvania courts is very clear, and the Supreme Court, that if there's an incidental impact simply because I have to solve a problem at the back property line, and, oh, by the way, there's an incidental impact on your speech, it's irrelevant that Galapos are trying to say anything about the Oberholzers. They're impacting the yard, and you can't live in the yard, and you can't live in the yard without seeing the signs. So, again, the unwilling listener, the unwanted speech, and the repetitive, unavoidable layout of that property where those signs are something that when you live in the back of your home, you see the signs.
Counsel, let me ask you.
Certainly, go ahead.
Counsel, your client received compensation in the form of monetary damages for the past, present, and future loss of enjoyment of their property as a result of this conduct.
Yes.
Why isn't that enough?
Why is that what?
Why is that not enough?
Well, because
Why should an injunction also issue?
I don't know where in the record the document is, but it's in the record. There was a confidential settlement agreement and release.
It's in the record.
Yeah, it's in the record. Of course, it's in the record. I got the signed copy here. And so, first of all, and by the way, both counsel, we drafted this together, and there's no argument that anything in the release is not applicable here, and I didn't hear.
Would you read it?
Pardon me?
Did you say it's confidential?
Well, you asked me a question about the release. Yes, the justices asked me a question about the release. I don't know.
So unless it's not confidential.
Is it in the record?
It's in the record. It's in the court record, but parts are redacted. The part that is redacted is the money. I believe the paragraph 1, which contains the provision for the money, is redacted in blackout. The paragraph that's not redacted, which is extremely important to the court evaluating this case in terms of what you were asking appellant's counsel, is paragraph 6. And so when the parties settled the case, the claims that it attached, one was dismissed on a summary judgment by yet a different judge in Montgomery County. And so then we had left standing were the defamation claim, the nuisance claim, and I don't know what else was.
False light?
False light publicity.
Seclusion was dismissed.
Seclusion was the only one dismissed. And so my argument legally in the briefing all the way through was that, well, your private nuisance survived, and inclusion upon seclusion is part of a nuisance claim under the restatement, so it didn't mean much as far as standing. But when the parties settled the case, the claims had already attached. And so as concurrently, contemporaneously, simultaneously with the parties settling the law claims for an amount I can't talk about, is paragraph 6. And it's here. This is the preserving language that the lawyers wrote. I wrote, and it says, notwithstanding the provisions in the preceding paragraph, the agreement does not prohibit, limit, or affect the Oberholzer's right to seek or pursue their claim for equity for injunctive relief against the Galapos in this action, identified by the number, prohibiting the present and or future posting of signs on Galapos property enumerated in paragraph 5 of this agreement, including a final decree with respect thereto, which claim is specifically not released in this agreement.
So essentially, they agreed that they couldn't use the fact that they paid damages against you in seeking injunction relief, which is exactly what they just did.
That's what that's what happened. Okay. So they're not going to defend on the basis that we had an adequate remedy and we didn't win on that, or the parties settled it, or that's gone from the case. And I think that the intent was the language. It says
they wanted to get to the injunction issue too. It just seems now that again, they're using
signs were, by Your Honor, Justice. By the way, the signs at the time the case was settled were up. No, I'm wrong. The signs, they were up when Judge Tolliver, entered his order on the injunction after the record was stipulated and submitted, and we had oral argument that went on like all morning. Then the signs came down, and then I went back to court, and this is in the record. Dr. Galapo was unhappy about taking his signs down, and so what he did was Dr. Galapo turned the signs around, so he complied, I thought, literally with the order, and I'll get, I'm still going to get my signage up somehow with my symbols and things. The sunlight would hit the signs, and all you saw were the signs in reverse. So I went back to court in Montgomery County for a contempt petition. Judge Tolliver, again, on the record, we heard some things in argument of counsel, and then Judge Tolliver entered the supplemental order. It was actually called an amended order. He just ordered that the fronts of the signs are not to be visible to the plaintiffs nor face in the direction of the plaintiff's home in order to ensure that none of the signs are visible regardless of their positioning. Again, he's not doing anything with the signs. These signs shall be constructed with opaque material. So within 24 hours, Dr. Galapo went out and spray painted all the signs black. So I believe they're probably still up, and they're, well, at this point, they were the back of the sign. He went out and, he painted, spray painted the signs black. You're right.
I think we're about to wrap up.
Yeah.
Do you have any other questions? Justice Mundy, Justice Dougherty?
I have one area that I do really want to talk about.
Well, I think we are about finished, so if you want to use it just as summing up, that would be great.
Summing up.
I want to spend 2 hours on trust, though. I'd appreciate it.
I'll do that if everybody wants to wait.
We did give a lot of time to.
This is really very important in the case.
All right, go ahead.
I didn't cross.
Stop talking so you can listen to me. I said, wait a moment. You can go ahead. We're going to allow this final argument. You're welcome.
I can't find it. Oh, I'll do it. Let me do it off. I'll do it. Yeah, it's in the. Well, no, it's not really quite in the brief, but I want to make this final argument because I think that this court does have the opportunity and the power to look at the Superior Court order for what it ordered, and it ordered that the matter be remanded to Judge Tolliver's courtroom so that he could apply the correct Madsen v. Women's Health standard. And Judge Tolliver applied time, place, and manner under Frisbee v. Schultz and Klebanoff and the other cases in Pennsylvania. And meanwhile, back at the ranch, Madsen v. Women's Health had come down, and Judge Tolliver did not adjudicate under that standard. That standard is that in this kind of case, with this analytical analysis and the framework of the facts, Judge Tolliver was required under Supreme Court law to apply the standard that his injunction restraining, we'll call it speech, or protest, notwithstanding, the injunction was required to burden no more speech than was necessary to correct the ill or the evil. And so therefore, on the dissent, Justice Stabile wrote that it would be Pyrrhic to remand back to Judge Tolliver's courtroom because on the same facts, on the same record, on the same everything, where Judge Tolliver didn't say anything about these signs and he didn't tell anybody to do anything about the signs except make sure they didn't face the property, he found it to be unnecessary for the lower court to have to revisit the case again and then enter another order and another memorandum, then start the process potentially over again. So I'm asking that this court would enter a final decree on the equity and find that notwithstanding the argument by the majority in the case that cited a whole lot of cases in the federal court, a couple in the state court that said if the court applies the wrong standard, it's got to be remanded. That's not an absolute piece of jurisprudence for this court to have to follow, and I think that there's enough latitude in the court's review here of this in order to enter a final decree that affirms Judge Tolliver's order and make a finding that on the record Judge Tolliver did reach that correct standard under Madsen. Thank you very much.
Thank you, Mr. Woodside. Thank you both. Mr. Minner, would you adjourn court for today?
Court is adjourned.